thoughts are today is the shortest.
काली आसु फाइल टा पाउन
काजी के तारीख आज को बरेगी
आज 3 तारीख
काल 4 तारीख
काली आनी परिबे मतलब परदिन आनी देबे होला ये फाइल टा आउथरे रिसाइट माने जाय कि लिस्ट बुली के आसे पड़ियो बुझपछंती मु जदी पाखर थांता मु टाणी कि आपण ओडिया एटा नै खेळ रात सेटा तुमते हे परियो दैट चैम्बर एक्सपीरियंस इज डिफरेंट हियर they list
17
item 12 is permitted to withdraw.
that give your memo sir
Yes.
yes quick
page 3 18 to 23
item 18 my lord
again
1 week after my lord
date कर देबे
16 3
हां
full
ठीक
comment
Item 22.
yes please
We'll check.
date कर देबे
16 4
yes please
page
अरे 13 मसे मैटर आपण देखु ना आपण ए सेम प्रॉब्लम 13 मसे को आपण 6 4 को रोकछन 24 मसे मैटर को रोकछंती तो लिस्ट को लाभ कोन हला मैटर गुडा
23
हां ठीक अछि आपण मु कहून के 6 4 आपण मु जानि आपण केतरा मैटर अछि କିନ୍ତୁ आपण सजौ ना
नहीं
यस 11 वर्ष पर 13 वर्ष टूर्नामेंट
24 to 29
Item 20.
Item 26 will not say. Like I know yesterday I received the complaint.
exposure yes please
item 1
May please.
see 93 item नाही आपण जे वेटिंग रूम रे अछंती फॉर आइटम नंबर 93 तो सेटा आउट को बेंच रो आछि एठी आई मीन आछि माने सी आस जाइछन सो ताको मेसेज करि परिबे से वर्चुअली रे प्रॉब्लम होबो से जानि परिबेनी जे से कोठी अछन जस्ट मेसेज दैट प्लीज चेक द कोर्ट नंबर हैला से मेसेज कर देले से तांकर नले से ताका मैटर सेठी से अप्लाई करथिबे एठी पडु नथियो ते सेठी अप्लाई करछथि वर्चुअली थिंकिंग बट एक्चुअली एठी अछन इंटरेस्टिंग yes yes please sir
Well, this is a
Rajendra Nath Raut for the appellant enhancement
no apportionment.
apportionment notice नियंतु
Well,
apportionment फाइल करले नी की
apportionment we have
रेफरेंस हैला नी की
reference made.
हां
Reference is answered against me.
ओहो अच्छा
And challenging
got
not
it
passed by the reference court.
got it
But there is there would
delay
be
हैनी कॉन्डन हैनी
delay conduct. Delay already
ये
conduct.
appear कोड नांती
Notice has
up
not.
to Mr. Divedi they are from they are your associates
Yes.
because they say that typing or
Yes.
Divedi is appearing for the other
No,
side
no.
along with you
Yes.
so Rajendra Nath Raut for the appellant Mr. Prem Kumar Mahanti additional standing counsel for R1 2 R2 to 8 2
Private parties
2
notice.
to 16 notice जाइनी पर्यंत
Notice जाइछि limitation रे notice जाइतला sufficient ହେଇଯାଇଛି ହେଲା ପରେ delay conduct.
आउतरे जेतु एटा substantial right to property and
Yes.
money
One thing I pray.
it is everything
One thing I pray that should. There is another connected appeal where this imprint order has been stayed there.
earlier la
By the, yes, by,
number
yes, that is law 45 of 2024.
ତାହେଲେ appearance ରେ ଲେଖୁଥିବେ ଏଥିରେ କିନ୍ତୁ ସନ୍ତୋଷ ଦ୍ୱିବେଦୀ ହେଇଗଲେ 5 ରୁ 10 12 15 and 16 ଲେଖା ହେଇଛି
There the OP number 6, respondent number 6 has filed that appeal. Here the respondent.
ସନ୍ତୋଷ ଦ୍ୱିବେଦୀ ଆପଣଙ୍କର ସାଙ୍ଗରେ
हाँ, ସେ ଆମ ସାଙ୍ଗରେ.
ଆଉ ଅର୍ଡର ସିଟ୍ ଲେଖା ହେଲା ଯେ 5 ରୁ 10 ଏଠି ସେଟା ୟୁଜ କରୁନାହାନ୍ତି ସେଟା ୟୁଜ କରନ୍ତୁ ଲୁକ୍ ଆଟ୍ ଅର୍ଡର ନମ୍ବର 3 ଉପରେ ଟଚ୍ କରନ୍ତୁ
ଏଥିରେ ଟିକେ ଦେଇଗଲେ
ଫର୍ଷ୍ଟ ଟାଇଟଲ ଦେଖିଲେ?
Yes, my.
Order in-
Santosh Dwivedi appeared for.
ନାଇଁ ମୁଁ ସେଟା ଦେଖିନଥିଲି
Yes.
ମୁଁ ଆଇ ଜଷ୍ଟ ଆସ୍କିଂ ୟୁ ଇଟ୍ ଇଜ ଜଷ୍ଟ ଏ କୋଇନ୍ସିଡେନ୍ସ ମୁଁ ଯାହା ପଚାରିଲି ସେଟା ହେଇଯାଇଛି ଅଲରେଡି
Sorry, madam.
I don't know why should we how do you know that
Yes.
that is in our side
Madam.
ତାହେଲେ you are saying that notice କଣ କରାଯିବ ତାହେଲେ ୱେଟ୍ କରିବା ନା ଆଉ ଥରେ ହିୟରିଂ ନୋଟିସ୍ ନେବେ
I have to wait. It will be better.
because that they
Yes.
will raise that issue
Yes, yes.
unless they appear
Madam,
they will say raise that the delay was not condoned.
madam.
Notices were issued by the coordinate bench by order notice in the IA. Notice in the IA was issued by the coordinate bench for condonation of reported delay of 65 days in filing the appeal. Office note shall be prepared by the registry indicating serially the status of service of notice on each of the respondents to tapre TO2 ହେଲା
Opposite.
2 to
60.
60 if any learned counsel has appeared for them and date of appearance. ପ୍ରଥମେ ଲେଖିଲେ କଣ ଲେଖିଲେ the office note ହଁ କମା then date of service ତାପରେ in case of appearance date of appearance the same shall be the report the report shall be prepared in a tabular form to make it convenient for reference. ଆପଣ ଡାକିବା ଲୋକ କିଏ ଅଛନ୍ତି ସଫିସିଏଣ୍ଟ କାହା ଉପରେ ରହିଛି ଆଚ୍ଛା ଭାଇ ନେକ୍ସଟ ଡେଟ୍ ଦେଖିବା let us see
Let's fix a day.
ସେ ଗୋଟେ ନୋଟ ଦିଅନ୍ତୁ କିଏ କିଏ ଆପିୟର କରୁଛନ୍ତି have you checked କି କୋଉ ଦିନ ସଫିସିଏଣ୍ଟ ହେଲା
So for the sufficiency is concerned, I have noted regarding the as per the
6, 7, 8, 12 no such person
6, 7, 8, 6, 7, 8 made sufficient.
it was line as in this regard although earlier notes put up by the registry shall be consolidated the concerned the called superintendent
Super.
ଆପଣଙ୍କ ଯୋଉ ଡିପାର୍ଟମେଣ୍ଟରେ ହେଡ୍ କିଏ
Super.
superintendent the concerned superintendent shall do the needful today when the matter is called none appears for any of the opposite parties apart from any of the opposite parties to TO2 14
Madam,
ଆପଣ କାପି
I am for my lord.
ଆପଣ ବି ମିଷ୍ଟର ଆପଣଙ୍କ ନାଁ ବି SK ଦ୍ୱିବେଦୀ ଆପଣ ଜଣେ ତାହେଲେ ମିଷ୍ଟର GN ରାଉତ ଆଣନ୍ତୁ
I am for 5, 6, 7, 8, 9, 10, and 12.
ଗୋଟେ ଲେଖି ଦିଅନ୍ତୁ କାଗଜ
It is.
My leg it's in the lordship.
5 to 10
5 to 10, 12, 15, and 16.
As per the
GN ରାଉତ ଆପଣଙ୍କର କାହାନ୍ତି where is GN ରାଉତ
it is correct.
Now I am Santosh Dwivedi.
what has happened
My
here Santosh Kumar Dwivedi is appearing for the appellant I asked him he said he has appeared along with me I looked at the order you are not there actually
Another
then he said yes I'm sorry I said because it is happening at our end so I should be sorry so unless you bring GN Raut it will be difficult find out GN Raut is there another GN Raut May not be Gajendranath, some Gokulananda, it's common name. Yes. Only Devendra. By non-Katal. Mr. S.K. Divedi, Learned Counsel, is present on behalf of respondents 5, TO2, 10, 12, 15 and 16.
Fine.
Avniman pe appear korna andi?
One is died. See.
No, 14 is dead, his name has been deleted.
No such person जो गहला कौन से
No, so-
कौन करी हो so Dwivedi ଆପଣଙ୍କର ଯଦି it is only a suggestion Mr. Dwivedi, I can't direct you to appear, it is only a suggestion.
My lord.
ଦେଖନ୍ତୁ
No, others 2 and 3 they are the contesting actually. I am the proper opposite party.
contesting में appear କରିବେନି କଣ କରାଯିବ ତାହେଲେ ହେଇପାରିବ ନା ତାହେଲେ ଠିକ ଅଛି ସେ ଉପର ନୋଟଟା ଯୋଉଟା ରହିଲେନି ସେଟା ତ ହେଇଗଲା ଥରେ
What is it? Jump out. Tell me.
I don't let fresh notice go to 2 and 3, my lord. They are contesting.
ଷ୍ଟାଟସ୍ କଣ ଆପଣ ଯଦି ଜାଣିପାରୁଛନ୍ତି ମୁଁ ତ ଜାଣିପାରୁନି ନା ଆପଣ ଭଳିଆ 2 and 3 appear କଲେ ବର୍ତ୍ତମାନ ତ ଦି ପଟ appear କରିଗଲେ ସନ୍ତୋଷ କୁମାର ଦ୍ୱିବେଦୀ ଯେ ଅସୁବିଧା ହେଇଗଲା
Aye.
କଣ ଷ୍ଟାଟସ୍ Two, three sufficient, Mr. Already. 2, 3 sufficient, Mr. Rao.
My lord,
Yes.
already sufficient.
So let us say they ଚାରିଟା prepare ହେଇଗଲେ ଜଣା ପଡିଯିବ
My lord.
ତାପରେ ସେ ସେଣ୍ଟେନ୍ସ କମ୍ପ୍ଲିଟ କଣ ଲେଖିଲେ appears for ଏତେ ହେଲା for the other respondents no one is present the respondents also are absent on repeated call list in the week commencing awaiting sufficiency of notice list in the week commencing this for orders the week commencing please do it ଟିକେ ସମୟ ଦିଅନ୍ତୁ କିଏ କଣ ଆସେ ଆପଣ ୱିଟନେସ୍ କରିବେ 9-3 yes next
I come to Yes, lord. This case, my lord,
so Alok Kumar Mohanty CGC
senior panel.
Mr. Alok Kumar Mohanty senior panel counsel for the petitioner yes
We are challenging the order of the permanent loc adalat, my lord. That is annexed.
scope of permanent local Adalat challenge
Yes, my lord. That
decision constitution bench
just 2 days back I have received. I have not
so
got.
kindly get through that
In my lord, one thing, my lord. In this case, my lord, the order passed on merit, my lord. The spirit of the loc adalat.
Mr. Mohanty, the problem is that you are not addressing the law, but going on arguing on merit. There is a stringent 142 direction,
Right.
not stringent. 142 law laid down by the Apex Code that you have to follow, appellant has to follow if local adalat orders are because it's a agreement, it's a consent order
Yeah.
agreed by both the parties.
Yes. That is.
Which is the decision?
I'm admitting I have not gone through because
Then that's the problem.
Yes. That is admitting.
You have started arguing as if it is a regular appeal.
No. That's why I'm saying you lordship. I'll look at that,
So
man.
why to spend time, sir? Why to spend time when you are not? You have to take a definite stand regarding what?
Whether that is maintainable or not.
No.
Order of the loc adalat,
There lies the problem.
madam.
पड़ेगा the petitioner Union of India challenges hard learned senior panel counsel for the petitioner. The petitioner Union of India challenges the order dated 29/8/2024 passed in PLA case number 10 of 2023 by the Lord PLA Khurda Bhubaneswar. Stop. The Lord Senior Panel Counsel has adjournment to address whether RO decision whether the petitioners have acted in consonance with the petitioners to challenge the order passed by the Lok Adalat. The petitioners to challenge the Lok Adalat have acted and followed the procedure laid down in State of Punjab and another versus Jalor Singh and others. AIR 2008 SC 1209. Reiterated in Vargavi Constructions and another. और नहीं लिख परिवे ना और पैराग्राफ लिखना तेरे Yeah, 2017 SC 4428. और देखो भी ना what you are typing and what you are doing. Supreme Court judgment when cited, they have to always have para reference. So it is examine current. Don't entertain this kind of litigation by the state. You never know where do you end up. Heavy cost, something. Now again you will go to Supreme Court. Supreme Court will ask you, since you are not even, I think this was not discussed. When they asked you for challenging a local adalat order.
One thing, for the moment, the section 19 of Schedule 5, you have gone through must have.
So your problem is that you are still stuck at the point that whether you can challenge or not. You can definitely challenge. Nobody is asking that. You are not asked to say that why you can challenge or not. It is a challengeable order.
Right.
But what is the issue then?
Issue to the authorities. The
issue is that whether you have followed Jalor Singh. Yes, next.
Let it come day after tomorrow because the execution case attachment order has been passed.
Where you have said in your petition that you did not agree to the Lok Adalat order. Where on oath you have stated?
Yes, my lord. Nobody has
Sir, don't give a speech because you are the counsel.
My lord.
Your client, the petitioner, must state on oath that we never signed or agreed to the order passed by the Lok Adalat. Where you have stated? Kindly show that. The learned counsel for the learned senior panel counsel, sir, also was asked during the hearing whether the petitioner has stated on oath that they did not agree for the settlement, conciliation, and the order passed by the Lok Adalat. Yes. He has adjournment to address on the same.
Item 3.
This approach has to change. This misguiding petitioner, misguiding itself in a wrong, illegal, process of adjudication. We are relying on you, Mr. Mahanti. They must rely on you.
Yes, sir. I am not disputing.
No, that's not a question of how can there be is it a property? There will be dispute. You must understand that if I start dictating, passing these kind of orders, interfering,
That's it.
my orders will be incorrect and broadly speaking, illegal orders also. It is your duty also. Yes, next.
Day after tomorrow, my lord.
Day after tomorrow, Anand?
Right.
But आपण ଏଇଟା answer କରିବେ ଏଇଟା further ଶୁଣନ୍ତୁ my effort is to make an effective hearing.
Yes, yes. Because
Today so this matter can be dealt with. From your response, it is apparent that these 3 points you have not discussed.
that's it.
And I have been asking that whether you have stated a note that you did not agree for the settlement. Or in similar, whatever you have stated, where you have stated.
Yes, okay.
Because unless it is there, you will be building castle in the air. No foundation, nothing, superstructure is standing. You must understand and this is how the system gets clubbed. This becomes a luxury for the central government because they can file it. They have a council and they don't have a basis to challenge. When they are asked to provide the basis, then comes the speed.
My wording is not.
It is not losing or winning a case before the local adalat. The parties agree. And both of them are happy because it is not against anyone.
Yes, yes.
So that we are spoiling by this method. The entire effort of the statute to make it amicable, we are spoiling it. And that is the concern of the court in Jalor Singh and Bhargavi.
My
Yes, next. Passover. Day after tomorrow, day after tomorrow, because there is some assignment, truncated hearing. If I am making serious hearing like this, Mr. Mohanty would allow me complete the sentence. Another half an hour will go. But Mohanty has taken adjournment. So you must understand. You never know when. So, Kali Pordon Rakunandi? Chalivana nahi? ठीक अच्छी चल रही दीटा कॉल करते हैं ठीक है केबे कहले अरे गते पजेशन मु कोन केबे मिस्टर महांती
day after tomorrow means ठीक.
आज के तारीख
आज 3 तारीख.
5 तारीख ताले ठीक 5 तारीख
Item 4.
I mean, VC Milord, item 4 of pray for a pass or after launch Milord. My senior elder brother, Mr. Mahant, will address my lordship.
अरे कोन आपण भिसी रे भी पास ओवर एटा ଗୋଟେ बढिया जिंस तो एटा मु त भी नथिली अरे लास्ट मैटर रे नथिले द लॉर्ड काउंसिल इज नॉट देयर पास ओवर यू आर प्रेजेंट एंड पास ओवर
अरे पुआ पुत्रार बाहागर भी गाँव पळे आछि माय एल्डर brother Mr. अमेय महांत will address my lordship. He is held up in court number 20 Milord.
Mr. Mohanty is the counsel also.
Yes,
अच्छा you are also there.
yes Milord.
ठीक अछि पास ओवर
Of like.
Item 5.
May I please?
Mr. The order for the petitioner.
The order dated 3rd December 2025, passed by the learned Judge
One-
Family Court Bhubaneswar.
Rejected or enhanced?
I want enhancement, only 10,000 for 3 mother, college and school going children.
Yes. Take notice.
Yes.
Third learned counsel for the petitioner. The petitioner wife is before this court challenging the quantum of maintenance awarded by the learned Judge Family Court Bhubaneswar by judgment dated 3/12/2025 passed in criminal proceeding number 196 of 2019. That is जोर है जो मुझे कहिबे ହେଲା criminal proceeding number 196 of 2019. Stop. ହେଲା ମୁଁ ଦେଖି कोने आपनकर जोता मते देखा जो आपण लेक्चर कि नाही सो आई एम आस्किंग ହେଲା ताले आपण याडू पळे आसनांती एपडे चेयर पळे आसन by the said judgment, the petition filed by the wife in the marriage and 2 minor children under section 125 of CRPC, CR.P.C. into bracket since repealed, seeking a maintenance of 1 lakh per month and litigation expenses has been allowed, comma, however, comma, the amount having been directed at rupees 4,000 for the petitioner wife in the marriage and 3,000 each for the two minor children. Issue notice along with this order. Requisites for issuance of notice by speed post along with registration and proof of delivery shall be filed within 5 working days. Within 5 working days. List after SR liberty to mention. Para, sub-para, it is further directed that the petitioners shall continue to receive the amount as directed by the learned judge family court.
5 lakh somewhat then he has not been paid even if 5 lakh somewhat in
Go for execution. Go for execution. What like that? We are prejudiced to their rights and contentions in the present application. Mr. Parad, actually, in fact, in most of the cases, they are not filing execution.
That
is adding to the, misery of the person.
is
They are pursuing litigation in a different court like High Court or in some cases in ADJ, where civil judge senior division in jurisdiction, family court is not there. Lot of litigation, I think, lot of litigation is there where it is almost aimless what they are achieving. And here is a case, there is the evidence, there is a lack of evidence.
ITR project central coordinator अच्छी 10,000-13,000 टका देखिए
You should have filed it is available in the website. Any institution is available in the website. This complete case of in a classic case where it could have been done but has not been done. What can be done? At the adjudication stage, when evidence is adduced, the evidence is neglected. And in digital age, nothing can be hidden. And many times we think that this is for the first time. But we realize later that this has happened earlier. This is not the first time that a person working in ITR produces 3,000 or 5,000. They are doing it.
land records भी देखा है सब देखा है 10,000 टका दी
land records the returnable, the value of land, if you convert into money, is very difficult. If you have sold a property and got some consideration amount, that is easier. But if you show that this is whether it is cultivable, what is the you are going to a very difficult arena.
ଏଠି 12 ଲକ୍ଷ ନା 15 ଲକ୍ଷ ପାଇଛି
You go for actually execution and pursue.
execution भी ହେଇଛି ଗୋଟେ କେରେ ସେ ଅଳ୍ପ 50-60,000 ଟଙ୍କା କଣ ଦେଇଛି
ଏଇଟା କରନ୍ତୁ because there is no stay order. Yes, next please.
Item 6.
I'm visual item 6 no item 6 will be taken over item along with
इसको बढ़े देली फाइल संग दे देली तो कौन कर एठी अछि आप मिलला तापरे 7 Mr. Das
Yes.
6 पास ओवर गले बुझले
May I please your lordship?
Yes.
My civil proceeding is,
Aditya Narayan Das for the petitioner. Yes, please.
yes, my lord. My CP is pending before the learned family judge court I filed this CP for the dissolution marriage under 13(1)(a).
Yes.
My difficulty is that
What is the prayer, sir?
prayer is for the early disposal of the CP, which pending.
Have you examined the law on this?
My lord,
Have you examined the view of the Honorable Apex Court on this?
no, honestly, I'm not.
That is,
Sir,
the Honorable Court has taken exception.
my lord,
The real exception I'm disposing of.
my lord.
The Honorable Court has taken exception to these kind of orders to be passed by High Courts. Any similar order would have been. Constitution, that's the 47.3. But kindly read it aloud so that I will also hear it because I have a copy. What is 7.3? Sir, last
Fine.
line, sir. Sir,
Constitutional code in the ordinary
it is not audible what you are speaking to the microphone.
in the ordinary courts should refrain from fixing a time-bound schedule of the disposal of the cases pending before any other courts. Constitutional courts may issue directions for the time-bound disposal of cases only in exceptional circumstances. The issue of prioritizing the disposal of the cases should be best left to the decision of the courts concerned where the case are pending and so on.
Kindly just turn over. Look, the last paragraph.
Last-
That page.
That
That
page.
page.
51,
57. 57 देखो.
57. Yes, my lord. Sometimes in quest of justice, we end up doing justice.
No, you are not reading.
Asian
We end up doing injustice.
injustice.
Upon both the
Doing injustice.
So leave it there.
Yes.
So this is the view of the Supreme Court.
But no, my lord, that's
So kindly read this again. So if you say that file affidavit, this is the only case pending before that court. Before we part, you can read it.
Before we part with this order, every day we notice that in several orders passed by different high courts while rejecting the bail applications in a routine manner, the high courts are fixing a time-bound schedule for the conclusion of the trial. Such directions adversely affect the functioning of the trial courts as in many trial courts. There may be older cases of the same category pending. Every court has criminal cases pending which requires expeditious disposal of the several reasons, such as the requirement of the penal statutes, long incarceration.
Incarceration. So I hope you now understand. Even in case of person who is incarcerated,
Yes.
the first three lines are important.
Yes.
There should not be an older case. There should not be so then. Now, so suppose you say that. The other side is not cooperating. Have you filed petition as per CPC? When the other side doesn't cooperate, there is a specific provision in CPC when the petitioner appears and the opposite party doesn't appear. There are different stages of trial. CPC is very clear. And these amendments were brought around 2001, 2002 to expedite.
Yeah, let's see.
Not you have to show to this court that you have filed a petition or not, what order was passed by the court.
No, my lord, I am not.
So the language you must understand that Supreme Court has used expression is very, in case where people are incarcerated, even then also that cannot be a ground to expedite trial. Unless say no older case is pending. No case is pending.
Yes, if there is no cases pending, older cases, then
So then how can then it amounts to discrimination by judicial order by expediting a particular matter. So
my grounds in this case, but I am not just submitting that. My ground was that,
no, I can't pass that order.
and
I cannot close my eyes since Mr. Das is appearing and constitution bench. Let it
not
be.
just I'm just informing.
Just turn. Then there is a further. Just turn that Justice Oak's judgment. The next page.
Yes.
Not that one. You are holding the constitution the single arm. Just turn the page. Next page. Read it.
And if last para. And 47.3. Constitutional courts
Leave it there.
in the
Thereafter. That is where referring to Allahabad Bar Association.
Yes.
Just read thereafter.
in the constitutional courts may issue directions for the time bound
Thereafter, after the quotation.
after the court. A direction which can be issued in exceptional circumstances is being routinely issued by the high courts without noticing the law laid down by the constitutional bench.
So please don't ask me to do that. Enough of comments from the High Court. Please give it. And that too in bail matters. These are civil matters. They don't boy national.
It is related to bail matters.
You must understand. Somebody is right because why the courts are interfering in bail matters? Because expeditious trial is a constitutional guarantee.
Yes.
They are incarcerated. Even that case also the Supreme Court has said that you should not do it. The reason is simple that the earlier trial the petitioner is in custody.
Yes, my lord.
You are not expediting the trial. But you are deciding in a particular matter, you expedite trial. That cannot be. And Justice Oak has said that the orders that should be passed sparingly. Exceptional cases are daily.
Sparingly.
So for that reason, I'm asking you which you are struggling now.
I'm
Whether older cases are pending or not.
now, older cases, some cases are not
Sir, you cannot be ambivalent. You have to say either pending or not pending.
from
Sir, 2022 in High Court, MAT appeals of 10, 14 years old are pending.
yes,
2022 CP, other CPs are not pending. And that too, a particular court, if not having exclusive jurisdiction, that is another issue. Suppose
direction is okay, but my difficulty is I am presently wasting
Sir,
based
that
on
difficulty is
High-
not to be looked at by the Supreme Court has said. Individual choices in litigation cannot be prioritized.
just for the last submission. I am not denying there is
You make the first submission, I have been prodding you. Make the first submission that whether you have moved the court for expediting because when the other side has not cooperated, what petition is filed and what order is
I am
passed.
not trying to.
Then I can't help you. I cannot help you. As a court cannot ask you that you do this.
No,
This is more kind of assistance to the lawyer. How can you move the High Court? Suppose you move a petition there.
that
matter
has
is
been
not taken
rejected.
up.
That has been rejected, so I can come from.
Yes, you challenge that on merit.
Yes.
And expediting civil matters, you see the observation in criminal matters, trials. You must understand that out of 1,000 matters, if I pick up one matter, then how can I close the eyes? It can, of course, you can, what I am directing, that in case you move the court for any order, that will be passed.
Lots.
And may I reiterate, that day I was not there. The thing is that in most of the cases, the lawyers do not file that petition because they are concerned with the learned colleague.
Yes.
In some cases, you are taking time.
Yes.
In some other cases, Mr. Mahanti is taking time. So when he takes time, you are not filing that petition. And when you are taking time, he is not filing petition. So that how the judge will, how can you say the court is not functioning? Court is taking up trial, sir. Out of hundreds, say in a day, say 20, 30 matters are there.
Yes, sir.
2, 3 matters are urgent.
Nobody is even, sir.
And one very important aspect, in fact, I have learned from you only, I mean, members of at length. And you are sure that no petition has been filed?
No,
No petition.
no such
So,
petition has
so as per instruction, I am observing that. As
yes,
per your
as per
instruction.
instruction.
Okay. ଗୋଟେ ଯୋଉଟା ଏପି ବୋସଙ୍କର ମ୍ୟାଟରଟା ଡ୍ରାଫ୍ଟ ହେଇଛି ଅଛି ଡ୍ରାଫ୍ଟଟା ଅଛି କାଲି କରେକ୍ସନ ଠିକ ଅଛି ମିଷ୍ଟର ସିଂ ଆଇଟମ 8
Item
ଆଜ୍ଞା ଆଜ୍ଞା ସେ ଆପଣ ବହିଟା ମତେ ଦେଲେ ନା ଆପଣ ପାଖରେ ଅଛି ସେଇଠୁ ନୋଟ୍ କରିଦିଅନ୍ତୁ ପୁରାଟା That constitution bench is very famous where Asian resurfacing has been overruled. I've just bench. They have that after a certain period, all the stay orders are stand vacated. Justice Mittal's judgment, what Mr. Das was reading, that in our quest of doing justice, we do injustice. In that context, he has said. And Justice Mittal is absolutely right. In one matter, here it was filed before me that the trial court during peak of COVID, applying Asian resurfacing has vacated stay order. So I had to say that without any application, even if you are following, he said, then Asian resurfacing was there. This from Balangir or Raukela. I remember, but you'll find that in peak second wave of peak COVID that has been vacated and final order has been passed. It becomes problem. Next, please. Next. ठीक है sir.
Item 9.
Somi Das for the Mr. Somi Das on behalf of Santosh Kumar Nanda for the petitioner. The petitioner, today other side rahibe Mr. Object pretty blank raheba. The petition has stated to be the petitioner challenged the order dated 26/5/2017. Passed by the Vice Chancellor, Odisha University of Agriculture and Technology. Which pertains to posting of the petitioner who is working as assistant engineer into bracket civil, comma, bracket closed civil, comma, देखी लिखी देवे ना, zone -1, भुवनेश्वर. What is it? IA file is IA number 1877 of 2026 has been filed with the following prayer. Again. Subilani. ବୁଝିପାରିଲେନି 26 ଦେଖିଲେ 25 ଦେଖିଲେ 26 1877 of 2026 has been filed with the following prayer. The IA is allowed the writ petition along with the IA and other connected and miss case 10319 of 2017 nalo upar oda 1087 of 2026 comma miss case number 10319 of 2017 then writ petition ete underline करके left margin heading कर दिया writ IA is allowed the writ application and the miss case and the IA are disposed of. Yes, please. Next.
Sebe,
My lord, may I please? This RPFM is infectious because final judgment has been derived on 7/1/2023. On that behalf, I have filed a RPFM 126 of 2023.
7-1.
In 7/1/2023, judgment has been derived. My lord.
Mr. Sujoy Shankar Singhdeo
My lord,
for the petitioner. Opposite blank. The learned counsel for hybrid board lecture. The learned counsel for the learned counsel for the petitioner being present at VC at Kalahandi addresses arguments. It is submitted that the RPFM was filed for transfer of
was challenging the interim order, interim maintenance order.
was filed challenging the order of interim maintenance dated 10/12/2021 filed by the Lorded Judge Family Court Bhubaneswar in criminal execution case number 58 of 2021 into bracket देखिए लिखिए arising out of C.R.P. number 150 of 2013. Stop. It is further submitted on by order dated 7.01.2023. What was disposed of, sir? CRP 150.
My lord, judgment was allowed.
The CRP 150 of 2013 has been disposed of. In view of the above submissions, nothing survives for adjudication in the present matter. The RPFM is disposed of.
My lord.
Copy of this order shall be forwarded to the Learned Judge Family Court, Bhubaneswar, to be kept on record of CRP number 150 of 2013, public criminal execution number 58 of 2021. Yes, next.
item 11,
कौन करिए तो नाहंती करिए पासो
item 12,
memo of date is filed by the learned counsel for the petitioner, which states thus. The petitioner, the petition is filed challenging the judgment and oblique order dated 11/10/2021 passed by the Learned Judge Family Court in criminal proceeding numbers 133 of 2019. Stop. By the said judgment, the petition filed by the wife in the marriage under section 125 of the CRPC seeking maintenance was allowed, however, directing for payment of a monthly maintenance of rupees 10,000 from the date of application, colon 25072019, instead of the amount of rupees 35,000 paid for stop. In view of the memo filed by the petitioner, the writ petition is disposed of. The RPFM. The RPFM is disposed of. Division. Copy of this order shall be forwarded to the Learned Judge Family Court, Jajpur, to be kept in the records of criminal proceeding number 133 of 2019, disposed of on 11/10/21. Yes, next. Memo as per the memo is taken on record. Scan copy be updated. Yes, next please.
Item 13. May I please your lordship? On behalf of my senior Vijay Kumar Mishra.
Your name, sir?
My name is Saurabh Dhala.
To Saurabh Dhala.
Yes, sir.
Mr. Saurabh Dhala, on behalf of Vijay Kumar Mishra for the petitioner.
Seeking the permission of the court to withdraw this present petition.
Sir, Vijay Mishra has to file that memo.
Yes,
That
sir.
is the memo filed by Vijay Mishra.
I know, sir. I have get that memo.
Memo ଆଣନ୍ତୁ ଆଣିକି ବିଜୟ ମିଶ୍ରଙ୍କର ବିଜୟ ମିଶ୍ର ଦସ୍ତଖତ କରିଛନ୍ତି?
Yes, sir. Yes, lordship.
ସର୍ଟ ନା ଫୁଲ?
Short.
ବ୍ରାକେଟରେ ଲେଖି ଦିଅନ୍ତୁ। କେବେ ସିଗ୍ନେଚର ଗୁଡାକ କରିବେନି ଡକୁମେଣ୍ଟରେ, ଜଷ୍ଟ ବ୍ରାକେଟରେ ଲେଖିଦେବେ। appearance କହିଲି। Mr. Dhawal on account submits that as per instructions received, the petitioner will not prosecute the matter. Stop. Memo of date is filed by the Learned Counsel for the Mr. Mishra for the petitioner, which states thus. The memo is taken on record. Scan copy be updated. The writ petition stands disposed of. This is RPFM. Again, it's a revision. The RPFM stands disposed of. Yes.
I'm 40.
Putin ki nanti. Tribunal. Petitioner none. The stamp report dated dash indicates that the matter date for stamp report whatever. The stamp report 28/7/22. The RPFM was filed, the petition was filed. The petition was filed on 25/7/2022. Stop. As per the stamp report, dated 31/1/2023, oblique 1/2/2023. Again. Sorry. और एमती कहीं भूलभाल होची। The writ application was the RPFM was filed on, the petition was filed on कितने तारीख को? नहीं 5/9/2022। तो ठीक से काटो दो, ठीक है। स्टॉप तापरे 1/23/1/2/2023. It is after 3 months of filing of the petition. It was pointed that the correct nomenclature would be WPC. Stop. Stop. 1 year after the filing, The matter was listed before the Deputy Registrar Judicial for removal of defect. Stop. And the following order was passed. Deputy Registrar into bracket J, tapare law jima, LAW ZIMA. Today, when the matter is taken up, none appears for the petitioner, nor the petitioner is present on repeated calls. So, accordingly, the matter shall be listed for orders. Aji कितनी तारीख है? Listed for orders on 5 आज की 6 को दिन रखिए on 6/2/2026 indicating the cause list that the matter shall be disposed of. Yes.
15. Pardon my lords, the conducting counsel is not well, therefore,
15 adjournment.
yes, yes. ma'am.
State has filed a petition for deletion of opposite party number 1, which is
ନାହାନ୍ତି ସେଟା ତାଙ୍କୁ ଛାଡି ଦିଅନ୍ତୁ ଟିକେ
sir non-formal party.
ଯାହା ବି ହଉ ସାର୍ ମୁଁ ତ ଆପଣଙ୍କ ପାଇଁ ତାଙ୍କ ପାଇଁ ଆପିୟର କରିପାରିବିନି ସେ ତ ତାଙ୍କ ଦେହ ଖରାପ ଅଛି କଣ କହୁଛନ୍ତି ସେ ଡିଲିଟ କରିବେ ନା ଆପଣ
Not a necessary. Panchayat Raj department has been made party, which is not the requirement.
sir you are for the petitioner or for the opposite party?
Myself.
I don't understand this.
No, opposite party.
This is a different jurisprudence. So have you solved that petition?
Yes, I have filed a petition. That is all.
Have you solved that petition?
Yes. Yes. Definitely, sir.
ଆପଣଙ୍କ ନାଁ କଣ କହିଲେ?
Amit Mohanty, A. Mohanty.
Mr. Amit Mohanty for the Mr. P.K. Mishra for the petitioner. It item
15, madam.
15.
Yes.
It is the learned counsel, the learned proxy counsel submits that the matter may be urgent due to personal difficulty of the learned arguing counsel. Accordingly, the matter shall be listed in the week commencing 16/3. तापर लिखिए IA number 13430 of 2025. Data last को देखिए IA number 13430 of 2025. The IA has been filed by the additional standing counsel. The IA has been filed by the opposite party state. It is submitted by the learned counsel, additional standing counsel, appearing for the petitioner in the IA. कितने नंबर था ये? 13430. That the petitioners in the IA want a deletion of OP number 1. अपन OP number 1 deletion चाहूँचंती.
Okay.
Copy of the IA shall be served on the learned counsel. एबे दे परिवे. Shall be served on the learned counsel for the
Yes, sir.
petitioner
Yes, yes.
within 3 working days.
Just now I am giving. I'm serving.
तापर लिस्ट कर देना. Yes, ठीक है.
I'm serving your lordship. Serving in court.
सेटा आपण मेमोटारे फाइल करे पड़ियो. आपण रिसीट नै की फाइल करले रजिस्ट्री फाइल कर.
That I am serving. Just I'm.
मु सर कोन
Sir.
सर
Then.
हो हे परिबिन सर.
Sir. Then
I cannot
I'll do that. I'll do that.
रजिस्ट्री को जाके मु कोन करिबा. आपण मेमोटा फाइल करले से रेकॉर्डेड रहइबो.
Okay.
Yes, next please.
Your Lordship, my humble apologies. On the last occasion, Your Lordship granted me time to file the objection to the delay petition. But the same has
Not filed, you are saying.
Fine. It may be granted one more week.
Mr. 16, Mr. Sahoo, you are there.
Yes, I am.
Mr. P.K. Sahoo for the review petition. 16, review petitioner.
Delay petition is there.
Is there?
Mr. Shakti Sekhar for the opposite party. IA 428 of 2023. The learned counsel, Mr. Sekhar, the learned counsel for the opposite party, I submits that he may be granted further time to file objection to the IE. How much? 2 weeks time?
1 week, Your Lordship.
He prays for further 1 week time. Stop kore likhiyo. He prays for further 1 week time. Accordingly, the matter shall be listed in the week commencing 9/3/2026.
Yes, ma'am.
17.
Madam Indian Malus are appearing for the petitioner in this case, Malus. The notice has to be issued to the opposite party, Malus. But we have already sent, look, twice or thrice, Malus, we have sent that notice. But for certain circumstances, the notice has not been served upon him, Malus. And moreover,
Is he appearing in any pending matter?
yes, Your Lordship, the annexure one,
You file that memo. Just obtain that instruction when he is appearing, when is the next date,
Malus.
so that it can be recorded and sent to that court.
And I have that date, Malus. The CP case was filed by the husband opposite party, man.
That who has filed, I am not asking.
I'll file a memo to
The question is very, simple and general terms. You file a memo indicating that he is appearing in such and such case before such and such court.
Malus.
This is the next date.
Malus.
Can you file that memo now?
Now, Malus. Within
Kaagaz diyantu. Pass over. Next. Next call karantu.
19.
अरे एपटे एठी देखिदेलेनी एठी जागा थिला आपण कुआडे पळौछन 19 भी समस्त तो आपण 500 वर्ष पढछन करंतु यस
20.
20 on behalf of Miss S. Mahapatra, may I submit, my lord?
प्लीज सर व्हाट्स योर नेम
Niroj Kumar Singh.
इन नॉट
On behalf of-
not Samal Mr. Niroj Kumar Singh on behalf of Miss MS Sachwati Mahapatra for the appellant.
Yes. In this,
Mr. PK Sahoo additional standing counsel for the R1.
I have challenged the appellants have challenged the order dated 1/7/2024 as at Annexure 7, page 48.
Correct, sir. So referral for what? Apportionment, referral for enhancement.
Enhancement, my lord.
You have to take notice.
Yes, my lord.
You have read the brief, prepared.
Yes, my lord.
Good. What is the grounds of challenge?
Grounds of challenge, the adjacent land of the other who have approached the learned law court has increased the value of the land. The adjacent land of appellants.
But pursuant to your application reference, the referral court has increased it. You want further enhancement.
You have further enhancement. I have, that's why I have challenged that order, my lord.
Anyway,
Approximately value are not given to me.
so the calculation at page 57, if you look at it, it takes care of that.
Kindly have glanced to page 38, my lord.
Not 38, sir. 38 is the not discussion. The conclusion is way ahead. You take notice. I was just asking you if I have prepared and whether you are thinking and reading all that. The petitioner is a land loser and has approached
We are the appellants, my lord.
the appellant. The appellant is land loser.
Appellants, my lord. We seek
Appellants are land losers who have approached this court under section 74 of right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013. Let's see that. The appeal has been filed against the judgment dated past 1/7/2024 in L.A. reference case number 280 of 2019, passed by the learned presiding officer, all capital LAR and R authority. Stop. The said LA case 280/2019 arises out of L.A. case number 13 of 2017 initiated by Zone Officer COM-LA Collector Baripada Zone. The acquisition was pursuant to ଆପଣ interruption କରିବା ପାଇଁ ଚାହୁଁଛନ୍ତି
डिले पिटिशन ଟା ଅଛି ଟିକେ
ଟିକେ ସାର୍ ସାର୍ ମୁଁ ଚେଷ୍ଟା କରୁଛି ଅର୍ଡର କରିବା ପାଇଁ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି The acquisition was pursuant to ଭୁଲଭାଲ ହବ ଟିକେ ଧୈର୍ଯ୍ୟ ଧରନ୍ତୁ Acquisition was pursuant to the notification dated
Yeah, annexure 2 might.
dated sir can never be annexed to.
uh, 28/5/2018 mile.
ठीक है पेज 49 देखिले पेज 50 राजा पेज 50
Yes, madam.
53rd line
2/3/2017.
आपण को जो डेटा पाइले कोठू पाइले
Annexure 2.
पेज
Page 21, my lord. The signature of the officer is 28/5/2018.
that is order under which section
$64.
41 नहीं तो 64 केंति होगी हुआ किड the date of notification has a relevance
Yes, madam.
correct notification dated dash 30 or fatty level issued by the land acquisition officer that is zone officer dash com dash LA collector LA 13 of 2017
13 of 2017, my lord.
Subarnarekha
Subarnarekha irrigation project, Baripada.
Subarnarekha irrigation project Boholoda Pursuant, the reference was answered in favor of though the reference was answered in favor of the present petitioners, enhancing the quantum of compensation Please again the impugned judgment.
Annexure 7, page 48.
जोटा ordering portion टा देखिए.
Ordering portion, my lord.
Page 57.
The appellants herein want further enhancement and hence the appeal. Para. The appeal has been filed after a reported delay of 201 days. ऊपर had not had counsel lecture था. लिख देगा. बोले इठी लिख. Issue notice in the IE as well as the appeal. Yes, Mr. Sahoo hela to.
My lord.
Notice in the IE as well as the appeal. The Lord Additional Standing Counsel upon advance copy served appears on web's notice. Let extra copies of the you require extra copy or
Not required.
the copies of the कौन लिख ले? Lord Additional Standing Counsel appears on web's notice on behalf of the opposite parties respondents. No further notice reissued. You will file objection to the IA?
My lord, you also.
Again?
Sir,
Yes, there is a delay of
140.
oral objection here lots from my counsel. Paragraph 2 is
Delay
the
कितने अपन पूछोंगे?
so he selection 5 orange दिन officer.
112.
Reported delay जोड़ा मुंह डाकिली से
One.
जोड़ा SR जोड़ा कोई. The Lord IA 6 time. The Lord AC 6 time to file objection to the IA.
Sir,
Seeking condonation of delay.
my lord and senior one.
Oral objection you lordship permit or I will file.
No, sir. I cannot step
Yes,
into your.
then I have to file better.
I cannot step into your shoes.
Yes.
You have to take a clear stand. Either you are objecting or not objecting. It is your choice. कौन लिख ले? If so advised. If so advised. List in the week commencing.
4 star.
4 weeks time दो.
AC.
23.
Obliged lords.
Yes, next please.
I'm sorry, my lord. Item 19, my lord. Just,
अपन ओटा पासवर्ड कोड ହେଇଥିଲା ନା?
my lord.
ठीक है.
Permitted to withdraw, my lord.
करेक्ट सर करेक्ट आपण कोन को आइतला सेतरे आपण गोटे कागज दि आइतला से कॉल करिवे आपण 19 डाकिलेनी
19 ରେ ପାସୱାର୍ଡ
नो डकिले टिके रहंतु सर अन्य मानक मैटर भी
My lord.
सेमती जी जेतबे आसीयो ठीक नो
My lord, sorry, I'm sorry.
सर राउत बहुत फाइन जेंटलमैन से जे खराब भाबेनी किंतु ताकर मने मने खराब भाबेनी
Sorry, sorry.
तो नो ताकू सरी कहर मोर कोन अछि मु तो जाले मैटर नउछि यस मिस्टर राउत
I am challenging the order dated 6/1/2025 and the present petition is wife petition mother. They are challenging the award of the maintenance. Sitting enhancement, my lord.
the wife
The delay is there.
the wife in the marriage is before this court challenging no seeking further enhancement of the maintenance awarded ଆପଣ ସେଟା ସେଟ୍ କରିବା ପାଇଁ ପ୍ରେୟାର କରୁଛନ୍ତି ଯୋଉ ଅର୍ଡରଟା ଆପଣଙ୍କ ଫେଭରରେ ଥିବ କେବେ ସେଟା ସେଟ୍ କରିବେ ନାହିଁ ଆଜ୍ଞା ମୁଁ ଭୁଲ ପିଟିସନ ଦେଇଛୁ ନା କଣ ନାଇଁ ତ 33
Yes, my lord.
to set aside the order dated 6/1/2025 ଆଉ ୱିଡ୍ର କାହିଁ କରିଦେଲେନି ସେଠି ଆପଣ ପିଟିସନଟା ସେଠି ୱିଡ୍ର କରିଦେଇଥାନ୍ତେ ଏଠିକା ସେଟା ସେଟ୍ ହବ This is one of like the Honorable Appeals Court has said, 44 cases between the parties. You file one petition, get your order, now come here, set aside that order.
Modify our
कौन modify mo? अपन तो simple कह रहे should be enhanced. Same line. अपन 6 line तो लिखिबे काहेकि set aside करिया ପାଇଁ चाहेबे ताको. If now let us assume it will be set aside. Then how the appellate court will again enhance it?
yes.
कौन लिख ले? awarded by the learned judge family court, Jajpur.
Jaspur.
By judgment dated 6/1/2025, passed in criminal proceeding number 268 of 2019. So, the said petition was filed by the petitioner under section 125 of CRPC, seeking maintenance of rupees. How much upon kete prayer kartile?
1 lakh, my lord.
1 lakh.
Yes, my lord. Petition on transfer.
Towards seeking कौन लिखले? 50,000 per month. 30,000 per month.
30 and 20, my lord. 50,000.
Upon 1 lakh कर देते तो
Sorry, what? 30 and 50.
30,000 per month for the petitioner number 1 wife and 20,000 for the petitioner number 2 child, minor child. Upon जदि 1 year 8 months child पे 20,000 claim करिए से केमती होगा आया?
मतलब से जो पढ़ुची साई इंटरनेशनल पढ़ी
काहे तो साई इंटरनेशनल पढ़ुचंती?
बापा
आपण कोठी पढ़िथिले?
बापा होजे साइंस
आपण जदि माने at this stage it will be difficult. से तरपरे do they stay in Bhubaneswar or
no, Jaspur.
boarding school?
Yes, ma'am.
Is it possible that you are seeking? So you can ask that education expenses.
There shall achieve.
Well, are other schools bad or what? Public?
No, that is admission for the.
In fact, we have all studied in government school with spending no money. Called like this? Stop. After considering the matter by the improved judgment, the Lord trial court has awarded rupees 25,000 per month to the wife. Is it less, Mr. That is how you want setting it aside. You are yourself also shocked.
No,
So I was thinking that how the wife is what setting aside the order granting maintenance. 25,000 for the wife, 15,000 for the son during PT. This is pendant land. This is not final.
That is the final.
So final in 125.
Yes, ma'am.
Sir, final in the no other petition pending.
No
Section 9.
other.
13 Hindu Marriage Act, 13 divorce. 9 restitution.
No, divorce is disposal of mother.
Then how it will be a 125 order? It has to be 25 order.
No, 25 no, 125 proceeding, separate proceeding. And divorce proceeding.
Divorce proceeding, has it been allowed?
No, I dismiss ma'am.
But filed by whom?
By my husband.
So then how you are saying allowed? You should say divorce was not allowed. They continue as husband and wife.
No, continue mother. They are living separately mother. Husband
Sir, 13 in context of 13.
13.
Somebody files a 13 application.
No, I am not filing 13 application.
Somebody,
Yes, ma'am.
not you. It is rejected. Then what is the consequence? They continue. Or like has directed sum of rupees 25,000 maintenance for the wife and 15,000 for the child. It is submitted by the Law and Counsel for the petitioner that inadvertently, in the prayer portion of the petition, a prayer has been made to set aside the impugned order dated 6/1/2025, though it is in favor of both the petitioners. Stop. Notice along with this order enhancement of the quantum of maintenance awarded. Stop. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within 5 days. Within 5 working days. List after SR, liberty to mention. Are you receiving this amount?
No, my lord.
Filed execution.
File execution and one RPFM also pending before this annulled by preferred by the husband, my lord.
You should have mentioned that in your cost title.
Yes, my lord, I mentioned.
For reducing the amount.
Reducing the amount, man.
Or he wants enhancement, file RPFM.
No, he was reducing the challenge in
The wife wants dismissal, he wants enhancement. Could be. I mean, the way the litigation is as observed by Honorable Apex Court. Have you got that recent Supreme Court judgment? Seen that?
Rajnesh
Rajnesh is very, very old. Latest is in 60 days, they stayed together for 60 days. Filed 44 applications, both together. The system is clubbed. The Supreme Court has exercised 142. This after, liberty to mention, it is submitted that the opposite party husband in the marriage has filed. Are you sure he has not filed for enhancement?
No, he has not reducing the challenge the
reduction.
Reduction, man.
So if it is taken up together, you want
yes, madam.
Setting aside, he wants reduction. What would happen? The net result is that it will be set aside. RPFM?
RPFM 48 of 2025.
48 of 2025. Arising out of the same order. Same judgment. Upon return of service, both the RPFMs shall be listed together. The learned counsel for the petitioner has the liberty. Have you appeared there?
Yes, madam, I am appeared.
The same other RPFM?
Yes, madam.
The learned counsel for the petitioner has liberty to serve copy of this RPFM petition on the learned counsel who is appearing in the other RPFM. Yes. Next, please. Pass over to
Pass over item 3.
Fresh admission. After recess question actually. Next.
Pass over item 4. Pass over item 6. 11. 17.
17 was of the memo.
Dude. Mr. N. Beuria for the petitioner. Regarding service of notice, office note put up by the registry indicates that pursuant to the notices issued by order dated, kebe order hitila agya? Koda gala order?
The first order was on 3-1.
Pursuant to the notices issued. Pursuant to the notices issued again. Pursuant to order dated
8/2/2024.
8/2/2024. The notice has been returned unserved with postal remarks. Quote quotation left without instruction. Hence, return to sender. Quote ends. The learned counsel for the petitioner files memo indicating that the opposite party is appearing in CP number 94 of 2023. Before the Learned Judge Family Court Khurda. The next date of posting being 7/2/2026. Stop. Accordingly, it is directed. Requisites shall be filed for issuance of notice through the Office of the Learned Judge Family Court Khurda within 5 working days.
On that day also I will file. On
So
7th.
don't take it personal. You may say that they may refuse, that's a different thing. Let it go through the court.
Within 5 working
The
days.
Learned Judge Family Court Khurda within 3 working days. Upon filing of the requisites, the same shall be sent for service of notice before the Learned Judge Family Court Khurda in CP number 94 of 2023, where the opposite party is appearing. So, the notice shall be served personally on the opposite party as well as the Learned Counsel appearing on his behalf. 2 sets of requisites be filed. Unutilized copy shall be utilized. So, the Learned Judge Family Court Khurda has requested to send the proof of service on the opposite party to the registry of this court to be kept on record. List in the week commencing 9/3/2026.
Malos, I have filed an IA for the stay of the proceeding, Malos. 7/2 has been posted for hearing, Malos.
This posting?
Yes, Lordship, the Judge CP case.
The memo ta likhle nahi? The memo is taken on record, copy is updated. Tapare ଆପଣଙ୍କର କୋଉ IA ଟା?
IA number
421.
No, that's 421.
IA number 421 of 2023. It is directed that upon filing of it is directed the further proceeding in the CP number 94 of 2023 shall be adjourned to a date beyond what କେତେ ତାରିଖ ଦେଖିଛନ୍ତି? 9/3 shall be adjourned beyond 16/3/2026 subject to the convenience of the Learned Court in session of the matter. Upon an application being made on that behalf, you have to file a petition there. And also you can file a copy of this order also. Yes. Yes. Yes, call.
19.
So item 19 permitted to withdraw, Lordship.
Sir, kindly give your memo.
In course of it, I am filing in before the registry, my lord.
Memo ta ekhi debe na order ta koribe. Mr. Sandeep Raj Panda for the petitioner. The petition has been filed challenging the judgment dated 19/3/2025 passed by the Learned Judge Family Court Jajpur in CP number 12 of 2023. By the said judgment, the petition filed under section 125 of CRPC was allowed on context, filed declining, filed by the wife in the marriage and 2 minor children born from the wedlock, then was allowed. Directing payment of monthly maintenance rupees 1,500 per month to the petitioner wife and rupees 1,000 each for each child to be paid by the opposite party as petitioner herein. memo of date is filed by the petitioner, but by the learned counsel for the petitioner, which states thus: the memo is taken on record, scanned copy, be updated. The petition stands disposed of. Copy of this order shall be forwarded to the Learned Judge Family Court, Jajpur, to be kept in the records of criminal proceeding number 12 of 2023, disposed of on 19/3/2025. Yes, next.
23. 23 kindly take up after launch. Mr. Lenka will do it.
Okay. Sir, after notice matter, since you have reached
Some documents.
no difficulty. I'm not telling you, sir. I'm addressing the bar, sir.
Mine.
Again, the same, we are not two together. Any other matters which you want mention or adjournment?
Yeah.
23 টা
When senior is there, just allow him.
Item number 31, that is to be.
Mr. Mahanti, please. Yes.
Item 28.
Item 28 disposal হয়ে যাবে।
Okay. So I'm coming back. We'll take it up.
20
Mr. Mahanti? 28. Okay. Wherever you want adjournment. Adjournment.
23 हाँ
Wherever parties are there, you can suggest a date, but please don't insist. We are adjusting the matters. So we'll give you the date. No difficulty. ଆପଣଙ୍କର?
24 item। ବ୍ୟାପକ ଅରୁଣ କୁମାର ଦାସ।
ଆପଣ adjournment ଚାହୁଁଛନ୍ତି? You suggest a date, if available, or he will just allow him to spread it over. Yes, madam?
23 ଟା
23 after lunch.
Adjournment. He'll give the date. Yes.
Item 31 also after lunch. After lunch.
Sir,
After lunch.
we cannot start hearing the after notice matter at 1. It has to spill over.
Item
So let him come, he's saying.
Item number 31 maybe adjourned.
Yes, he'll give you the dates. He's just posting in the computer. I'm not passing any order.
Recording stopped.
Your matter is 28. Mr. Mahanti will come or he's busy? Acha. Or if you can, you know the instruction, then you can tell also. Passover ta kete rakile apan?
Item 3.
Yes, please.
Yes, your lordships may kindly recollect that matter where section 24 has been allowed in favor of the wife, directing the husband to pay some.
And, yes, order dated 20th of January.
No, 3/1/2025.
No. Last order passed by this.
Yes.
So what we discussed, so there will be some.
Yes.
So order is 12/1. First is 12/1.
Actually, he is paying rupees 5,000 for the last 4 to 5 days. And 5 days when the matter has been fixed. That in that view of the matter,
Total, what is the outstanding?
Outstanding about
Because I remember this. The outstanding was, and also I said that I did not pass order, I'll recollect. So outstanding kite?
Outstanding.
And because she is a unwilling payer. He doesn't want to pay anything, not he. So you wanted let that instruction come?
Actually, my instruction is he is paying for the last 4.
So you bring that on record, not total outstanding and how much has been paid.
Total outstanding I have not paid.
So you
paid only
no instruction. ସେ 2 ଲକ୍ଷ ଟଙ୍କା
2 ଲକ୍ଷ ଟଙ୍କା ନାଇଁ ସେମିତି ମୁଁ ଦେଇନି ଦେବି ବୁଝିଲି ଆପଣ
ଆରେ ଆଉଟଷ୍ଟାଣ୍ଡିଂ ସେମିତି ମୁଁ ଦେଇନି ଆପଣ କେମିତି ଉତ୍ତରଟା ହବ ତାର
ମୁଁ
ଟୋଟାଲ ଆଉଟଷ୍ଟାଣ୍ଡିଂ ସମୁଦାୟ କେତେ ସେ କେତେ ଦେଇଛନ୍ତି ଆଉ କେତେ ଦେବେ
60,000 ଖଣ୍ଡେ ହବ
ଆଉଟଷ୍ଟାଣ୍ଡିଂ
ହବ ମୁଁ ତାର ଦେଇଛି କେତେ 20-30,000 ଦେଇଛି
60,000 ଟଙ୍କା ଦେଇ ଦିଅନ୍ତୁ
ପୁରା 60,000 ଦେବିନି ମୋର ପ୍ରେୟାର ହଉଛି ଆପଣ
ଲିଭ୍ ଇଟ୍ ଦେୟାର
ମୋର ଟିକେ ପ୍ରେୟାର ଟା ଶୁଣନ୍ତୁ ଟିକେ ଟିକେ ମୁଁ ଭାବୁଛି ଆପଣ
ସବୁଦିନ ପ୍ରେୟାର କରୁଛନ୍ତି ମୋର ମନେ ରହିଗଲାଣି
ଆପଣ ମନେ
ଆପଣଙ୍କ ପ୍ରେୟାର ଏକ୍ସାକ୍ଟ ୱାର୍ଡ ବାଇ ୱାର୍ଡ କହିଦେଇ ପାରିବି
ପଛେ ତଥାପି ମୁଁ ଇନସିଷ୍ଟ କରିବି କାରଣ
ପ୍ଲିଜ
ମୋ ଡ୍ୟୁଟି ହଉଛି ମୁଁ ଇନସିଷ୍ଟ କରିବି
ନାଇଁ yes I mean since you have insisted on the fast effectively so that is how the memory is created
Yes.
otherwise I have not interacted with any party in person
No, more what I submit before your lordship, the very purpose and object is to benefit the person who he or she is on.
no you don't make you cite some judgments on 24 if you have read
I have
particularly Rajneesh versus Neha and other judgments and the scope of this is RPFM.
This is not RPFM.
This is WPC. But in nature of still it is lesser than revision.
Yes.
So read the judgment of Justice Deepak Mishra on RPFM. Also some judgments that how the Supreme Court has dealt it. They dealt with Section 24 applications. What should be the view of the High Court or the trial court if they are?
My argument is keeping in view the changed scenario, the law has to be changed.
No, law I cannot change.
Yes, it can be changed because that is the law.
Parliament.
No, law is made. Parliament is.
Amendment of any statute has to be by the Parliament.
That is, I am not there. From time to time, court has taken different.
If you have a like the last like on 21 as well as on 12.1, I had suggested that if you are citing any decision on this Supreme Court decision, then please cite that I will interfere in an amount of 5,000 to be paid per month by the husband to the wife as Section 24 maintenance pendent allied. And also I am of the view that for a payment of 2,000, 5,000, even if he has not filed, the wife cannot say, because the argument is the husband has not filed 5,000 just now before madam was there. The award is 20,000 for the wife, 15,000 for the child. Still there is appeal. 1 year, 8 months. Now she is 3 years. So then I said, is it not adequate? He says that the child will study in Sai International. Sorry, yes, Sai International. So if that kind of argument is made, definitely your point, it has to be noted. Because it has to be a balance.
Balance.
It has to be balance.
That is what I.
But the attitude is not to pay 5,000.
Not to pay 5,000, keeping in view the fact of that particular case. Here, she is a sub-inspector in police, and I am.
If you remember, I used the word with greatest of respect, even if she is DGP. Suppose, let us assume he is the he is in the he will get.
No.
Still he will get.
जो सुप्रीम कोर्ट रो से जो जजमेंट रे
देखो कोतरे नहीं जे डीजीपी पाइबनी rather the principle is if the wife if she was a police officer and she married and the status of living she has to continue and if, you have to read that Justice Deepak Mishra's judgment on this.
If your lordship will kind enough
आपण स्टेट अवे जोदा आपण को रिक्वेस्ट करछि बाहर रह कर आपनकर जोथि सुप्रीम कोर्ट कहिला जे जदि पुलिस सब इंस्पेक्टर को मेंटेनेंस दिया जीवनी कि एस्टेट पेंशन दिया जीव तो नाही जदि आई कैन नॉट डेवलप दैट
सेटा कहूनी मो कहिबा कथा होची स्टेटस ऑफ द पार्टी अर्निंग कैपेसिटी ऑफ द पार्टी अर्निंग कैपेसिटी डिफर फ्रॉम केस टू केस
अरे सेटा आपण यू आर स्टेटिंग द ऑब्वियस I may look like I have not understood or I do not understand the law. That's another thing. So by stating the obvious, the case is not going to. The request is very specific. You have to cite a decision that where the wife is earning say 2 lakhs.
Better than the husband.
Whatever. So she will not be paid. She will be paid zero maintenance. That is your submission.
Yes.
That is how he is not paying. But the husband is behaves like Supreme Court, but I cannot. You have to follow Supreme Court's
ନା ମୁଁ
judgment.
ସେଇଟା କହୁନି
So now I have consolidated and I have started delivering judgments on this.
ମୋର ଗୋଟେ ରିକ୍ୱେଷ୍ଟ
Regarding interference in the grant of section 24, if you
your lordship may kindly observe or dispose it of with a direction that since I am paying, but
no, there is no proof. No oral.
I will file an affidavit.
You filed the affidavit, how much is awarded, how much you have paid, what is the due. And Rajnish versus Neha says from the date of application. That I cannot override.
Yes.
So the date of application is?
Date of application is
It is 5 years.
Again?
60 months. It comes to 3 lakhs.
ନା 3 lakhs ସେ ବୋଧେ କେବେ ମୁଁ ଟିକେ ଦେଖିଦିଏ ମୁଁ ଏକ୍ଜାକ୍ଟଲି ଆପଣଙ୍କୁ କହିପାରୁନି
2020 ପିଟିସନ ଟା ସେଥିପାଇଁ ଆପଣଙ୍କର ଏଥିରେ କିଛି
ପିଟିସନ ହଉଛି ମୋର ମୁଁ ଡିଭୋର୍ସ ଫାଇଲ କରିଛି ଡିଭୋର୍ସ ରେ
24 କେବେ ଫାଇଲ ହେଲା
ହଁ ସେଇ 24 ଟା କେବେ ଫାଇଲ ହେଲା ଏକ୍ଜାକ୍ଟଲି ସେଇ ଯୋଉ ଯେବେ ଆପଣଙ୍କର ଗୋଟେ ମୁଁ ଦେଖଉଛି
13/9/24
ଆଜ୍ଞା
13/9/24 13/9/24 ରୁ ଆପଣଙ୍କର 13/9/25 ହେଲା another 9 plus 3 15 ମାସ ଏପଟେ ହେଲା ଜାନୁଆରୀ 16 ମାସ 16 ମାସରେ it comes to 80,000 ଟଙ୍କା 5,000 କହୁଛନ୍ତି ନା ଆମର 5,000 ତ ସେ ଡିମାଣ୍ଡ କେତେ ସେ କରିଥିଲେ କେତେ
ସିଏ କରିଥିଲା 30
ଆପଣ ଆଉଟଷ୍ଟାଣ୍ଡିଂ ଦେଇନାହାନ୍ତି 1,56,000
ନା ସେ ଯୋଉଟା ଆପଣଙ୍କର 1,56,000 ଜିନିଷଟା ହଉଛି ଆଜ୍ଞା ଦିଟା ପ୍ରୋସିଡିଂ ଗୋଟେ ହେଲା ମେଣ୍ଟେନାନ୍ସ
ଆଉଟଷ୍ଟାଣ୍ଡିଂ देयर इज ए फाइंडिंग
ଆଜ୍ଞା
दैट एक 1,56,000 और प्लीडिंग व्हाट एवर आपण कहबे 1,56,000 आपण ଦେଇନାହାନ୍ତି 125 सीआरपीसी रे जोतरे की
सेटा मु पेमेंट ऑलरेडी मेड सेटा जोटा रिफ्लेक्टेड हेची
ना सेटा मु सिट कल दैट इज ए प्लीडिंग और ए फाइंडिंग
ना
so since you are now because now I have started arguing the matter for you these points you have to argue before the court this was the direction earlier this much I have paid and this is the outstanding there and today so already I am paying so usual difference in case of a अपन जदि न सुनिबे से प्रॉब्लम हो मु भी मो कथा देखि सुनंतु there are 5 proceedings claiming maintenance assume say 2 proceedings DV 24 125 3 proceedings so the principle is that it should be taken up consolidated 5,000 6,000 10,000 in 3 cases that should not be so now the wife goes on filing when you appear for the wife you file petitions then the respondent's counsel duty is that he has to show to the court pursuant to this order I am already paying this
सेटा मु देखि देइथिली कोठी
so obviously that will be if so naturally that will be factored into the subsequent order earlier payment of maintenance is factored into the subsequent order
actually what has happened I am paying
so now but
600
on this so according to you 1,56,000 due has been paid
not to her that मु सेटा टिके क्लैरिफाई करूची
से चाइल्ड को
केवल 120
चाइल्ड को that is the pleading
no
आपण जो भाबुचन जे मु कहूची not to her I am not saying because you are not looking I am looking at the pleading the pleading is that child is paid so suppose now the child will be paid another some money so that is a factor to be considered all those things so whatever it may be
किथिरा आपण
5,000 टंका
एइथिरा आपण कंसीडर करिवेन
आपण तो सुनिबेनी कि बुझिबेनी भी ना आपण अबुझा हे गले
नाही मु अबुझा
125 रे जदी 120 पिटिशन के पिटिशनर के देखंतु
सीए
sorry 24 रे
पिटिशनर होची only wife
can the child be a 24 petitioner
नहीं
so but it is a factor that what is the requirement so 24 रे जदी requirement गए wife देखेबो से कहि पारे जे child पे एते खर्च होची because that is a requirement in 24 but it cannot be a petition by the child like
only नहीं सेटा को से देखि परिबनी it is
like say मु से पर्यंत एते लॉ पढिनी she has to disclose that if she is requiring 24 maintenance she has to are see आपन को केस कथा पढिनी it is a general discussion so wife now says that I require this much for the child this much for me this much for education this much for so there if she prays something in the 24 application for the child naturally the court has to take note of the earlier payment for the child
ठीक अछि
Because child has also 2-3 proceedings. It can be the domestic violence and other 125 and another that guardianship maintenance. That can be. There can be possibility of 3 proceedings.
Not all. Only one.
Who is saying all पाइबो बोली?
ମୁଁ ସେଇ କଥା କହୁଛି।
ଆପଣ ସେଟା କାଇଁ କହୁଛନ୍ତି? ଆରେ ମୁଁ ତ ଆପଣଙ୍କୁ ସେଟା କହୁନି। So calculation of the amount has to factor into all the payments being made. That is a short point I am trying to make you understand. So naturally ଆପଣ जोटा 5000 ଆପଣ जोटा दउचंती ଆପଣ केते आउटस्टैंडिंग अछि और केते दउचंती that to bring on to record.
ठीक अछि मोर एफिडेविट देई देबी मोर एटारे
बट बी श्योर ऑफ द आपण निजे श्योर नथि केते डायरेक्शन अछि
डायरेक्शन अछि 3/1/25
वर्षे हे गेला
3/1/25 मोर actually what I want
and you also go through the pleadings of the wife opposite party in the divorce proceeding what defense he has taken for living companionship of the husband. So that is also a factor to be looked into by the court.
But not at the time of 24.
Who decision?
कुछ डिसीजन दरकार नहीं ताले व्हाट इज द
आपण वीडियो नो जे बिना डिसीजन सुप्रीम कोर्ट रे मेंशन करू
कुछ डिसीजन खोजले आपण डिसीजन दउ नांती
मु देख
आमे कहूछ आपण दियो
नहीं से मु वर्तमान आई विल नॉट एक्ट एज ए सुप्रीम कोर्ट जज there are settled propositions what I am seriously these are all settled. I am not discovering it. These are we are not, I am not discovering it. Voluntary desertion and involuntary desertion are treated differently.
Yes.
Voluntary desertion will not be entitled for maintenance because it's a ground.
Yes.
It's an aggravating factor for the wife not to receive. And involuntary desertion are compelled because of the situation.
That is true. That is true.
So now you are saying that.
No, you say part of the more whether that aspect has to be taken into consideration at the time of considering an
application. Madam, what you are discussing not regarding your case, it's the general because since you are saying that you are not sure what amount he has paid and since when he has paid, so you prepare a chart, what was the direction and how much he has paid in different directions.
You actually submit करियार आपण को एक मो इंसिस्ट करियार होची जे जदी नोटिस ता जानता एवं एटा मीडिएशन को पठी दिया जानता मैटर
mediation in maintenance. No mediation in maintenance.
सब दिन होच
सेते सब दिन करूनी
आपण करना किंतु होच
सेटा बहुत भलो कथा मेंटेनेंस रे सो yesterday or day before yesterday maintenance mediation after 6 months mediation failed. The reason being in mediating in maintenance I cannot direct. Let us assume I am the mediator. अपन तो कौन सी सेंटेंस कंप्लीट करे को दोना कंसिलिएशन ऑर्डर कौन हे परियो mediation maintenance है
not regarding maintenance.
So does the mediator or the court has that power?
Yes. If it can be disposed of for all times to come, mediator is having a role in it.
24.
What is the purpose of mediation?
If allow koribe, then I will complete a sentence. 24 arises out of a 13 proceeding.
That is true.
Who is saying false?
Yeah.
Single bench does not have jurisdiction to deal with 13. You are saying indirectly that.
Nah.
Yeah, I will send it to mediation so that 13 is settled.
No, I am not on technicalities. Overall views, what is the purpose of mediation to dispose it of?
You are not on technicality, I am on legality. I can't pass illegal orders. I lack jurisdiction to entertain 13 application. But I will pass orders in 24.
No, 24.
Then what is the difference between the RPFM and MATA?
Again?
24 RHS is a... Anyway, ଆପଣ ଯଦି file କରିବେ last the same thing. If you file କରିବେ then you mention it, no difficulty. But not on your oral, it is submitted by the learned counsel for the petitioner that the petitioner is paying the amount and directed by different orders, by different courts. To substantiate the same, the petitioner shall file affidavit indicating the details of the orders passed, the amount directed, amount into bracket plural, S. Orders passed, amounts directed, and details of payments made. How much time? The affidavit shall be filed within 10 working days. List in the week commencing
That's my
2-3-2024.
published.
Yes, text. The matter was mentioned, Mr. Mahapatra. Yes, sir, Mahapatra.
Passover item 4.
Acha, auri Passover achi. Oh, sorry. I'm sorry. He is calling Passover. I didn't realize that. None appears for the petitioner, though the matter is called thrice over.
I'm a VC, my lord. Item 4, I am VC.
Sir, it has been called thrice. That should not be the trend.
No, sir. Mu sir rohichi. Se sir, my senior, Mr. Mahanti, well, to address.
Sir, it there was no. It came to
Sorry, sir. I'm sorry, sir.
I'm very sorry that you have to interrupt me. And
Sorry, sir. He is authorized, sir.
The matter is adjourned thrice over by the Lord Counsel, Mr. B.K. Naik.
Recording in progress.
Virtual Court, High Court of Orissa at Noagarh.
Sorry.
It is submitted that the Learned Arguing Counsel has personal difficulty. Accordingly, the matter shall be listed in the week commencing 23-2-2024.
Sir, टिके sir ग्रीफान sir गोला काली की थिला केस टा तळ कोर्ट रे आजी अछि पुनी सर काली की अछि स्टे सर सुन नांदी से सही सर कोन सर रिलीफ सर कोन सर हम रिलीफ पाइबो सर जस्टिस
Judges and much less the judges of the district court. No personal interaction. Whatever you do, any order he passes, you challenge. He doesn't obey order, you file appropriate application, but it cannot be a matter of discussion.
अरे केस पेंडिंग अछि स्टे ऑर्डर देलु हाई कोर्ट रो सुप्रीम कोर्ट ऑर्डर भी दिया सर प्रति डेट रे फर्स्ट सर पुनी काली की अछि सर टिके कोन सर रिलीफ जस्टिस कि सर पाइबो हम सर
मिस्टर नायक भिसी रे आपण लैपिंग स्पीच हेले प्रॉब्लम होची आपण सुनु नांती आपणकर जदि किछि ऑर्डर को जज को माने माननीय अदालत ये फाइल करियर अछि फाइल करंतु एटी ओरल सबमिशन करंतु नाही
ना सर पेंडिंग अछि क्या सर मु कहू सर सेटा सर सबमिशन करूची सर सीआरएलएमसी 373325 इज पेंडिंग
व्हिच आपण जोटा कहउचंती को पिटिशन प्लेस करूचंती व्हिच मैटर यू आर आर्गुइंग
the present case is arising out of which the present petition has been filed arising out of the same proceeding one another case is pending before my lordship divisional court
आपण जो आर्ग्यू करूचंती स्टार्ट को आपण बटन
125 proceeding against this petition arises against 125 proceeding
को कहउचंती आउथरे कहले सुबिलानी
sir this petition which I have filed for a transfer
आपण आर्गुमेंट करूचंती ना पास ओवर करूचंती ना आर्ग्यू कोन करूचंती
सर मु सबमिट करूची सर
को पिटिशन दा
सर प्रेजेंट केस टा जो फाइल है सर ट्रांसफर पे एटा सर दिस इज केस ऑफ रिलेट्स टू 125
से जो ट्रांसफर पिटिशन फाइल है स्टे हिची की
एथिरे सर आज फर्स्ट टाइम आसी जी हां सर आगुरु स्टे हिचे कनेक्टेड केस रे सर
ठीक अछि सुनतु आपण अरे आपण मन रहने जदि आपण मन रहने रिप्लाई आउथर देखंतु आपण सकाळे कहले म आर्गुमेंट करबिनी लर्नेड आर्गुइंग काउंसिल करिवे कलेनी सेकंड टाइम फेर कॉल होला आपण नथिले थर्ड टाइम रिटर्न आफ्टर रिसेस कला बेलको आपण आर्ग्यू करे चाहउचंती ना कोन
सर मु सर हां हेति सर कहू सर
चले पेपर लिखिए कौन लिखिए yes Mr. Mahanti
yes
you will argue or you will argue
sir Mr. my elder brother will argue my lord
after the learned counsel has argued for the some time the learned arguing counsel has arrived and starts arguing the matter and accordingly he is heard yes
sir this matter lord sir can I say earlier your lordship's order dated 17 lord's order dated 27/10/25 page 17
yes
the lordship granted the interim order lord's para 5 lordship
court argue korchonu sir
sir
TRPC number
TRP CRL
number 13 earlier order dated
page my lord 17 para 5 as an interim measure
I have to read that page
yes
page 17 para 5 yes
as an interim as a director that on an application being filed by petition seeking adjournment in criminal proceeding, so and so, Lord court in session over matter shall do well to adjourn the matter for a period of 4 weeks.
Yes.
Lord, thereafter, now the case has been listed. Lord, pursuant to Lordship's direction.
So that application is listed today again.
Yes, Lords.
But why fresh admission notices were issued?
Yes, Lords. Lords, what happens
No.
in obedience?
No, CRLMC, this is different matter, Mr. That is CRLMC 3733.
3733.
So for what?
Yes, Lords.
CRLMC for what? Because that petition is not before me. Let him come. Let Mr. Naik come. Mr. Naik is thoroughly confused. So he has confused you. And he has adjourned the matter on 3 times, passed over the matter for 3 times.
Lord, because I'm
He just,
sorry, he has,
you might be surprised that how do I know this? Because he just now said, earlier order passed. So I could not also follow what he is saying. But at least you have referred to the page because it is listed for fresh admission, then where it was listed. So in fact, I could not follow. So,
Lord, I take up tomorrow.
the date of the consent? 23 question. Kali hai paribo na aaj nahi paribo listing jai paribo. Por din nahi paribo.
ସେ କଣ କି ମୋର ଆଜି
No
ଦୌଡ଼ିକି
difficulty.
ଏକର ସେକର
Not at all, no difficulty. But when he said that earlier order was passed, he did not refer to the page like you are referring. So even I could not understand. Now when you see the page, it is another case. And how they're related, I have to now decipher.
ମୁଁ ସେ ଚେଷ୍ଟା କରୁଥିଲି ଆପଣଙ୍କୁ ସେଥିରୁ କହିବେନି ମୁଁ ପୁଣି recollect
ଆଜି ହେଲା 5/3 ପରଦିନ ମାନେ 5 ତାରିଖ 5/2 not 3 5/2 item 6 also same
ଆଜ୍ଞା
6 ଟା ବି same order. Yes, next call କରନ୍ତୁ pass over.
Item 11.
None appears for the petitioner, though the matter is called thrice over. To grant further opportunity, list in the week commencing 9/2/2026. 9/2 करिवे ना लंबा डेट करिवे 23/2/2026. Yes, next.
Item 23.
23 ନୁହଁ ଆପଣ ତାହେଲେ ଅନ୍ୟମନସ୍କ ହେଇଗଲେ ଗୋଟେ ମ୍ୟାଟର ମେନସନ କରିଥିଲେ ସେଇଟା ପୂର୍ବ 23 ମୁଁ ଆଇ ରିକ୍ୱେଷ୍ଟେଡ ମିଷ୍ଟର ଲେଙ୍କା that just give me a moment. One matter it was mentioned to be disposed of. Mr. Mahapatra, your matter.
Similar matter.
88.
Similar matter.
Just give me a second.
Man.
ବହୁତ ଗୁଡେ ପାସଓଭର ବହୁତ ଥର ଟିକେ ସମୟ ଲାଗୁଛି. Mr. Srinivas Mahanti for the petitioner, Mr. Satyanarayan Mahapatra.
Put IA file it. IA 1912.
The matter was mentioned by the Lord and Council for the parties to be taken up as there is possibility of the matter being finally disposed of. Accordingly, the matter is taken up after recess. The launch court also is there. IA sir, IA 1915 of 2026.
ସେଥିରେ annexure ଗୋଟେ ଅଛି 7 ମାନେ page 7.
Yes.
But
Yes, it is there.
ଏଥିରେ ଗୋଟେ amnesty scheme ବର୍ତ୍ତମାନ ସେ ବାହାର କରିଛନ୍ତି ଇଏ ସେଇ.
Yes, they have notified. I have passed orders. But what usually the Lord and Council are saying, I have asked them that I'll dispose of. They say that let the matter kept pending. And it's a welcome change that you are saying, let it be disposed of. But where is Mr. You are.
I'm for the corporation.
I'm so sorry. I thought Mr. Ray.
No,
here.
I'm for the corporation.
Okay. So it can be disposed of or
Disputed direction.
the amnesty order ta upon question disposed of.
Oh, similarly, ଅଛି. ହେଇଛି approved.
Yes, yes. I have some difficulty in forgetting. Somnath Mishra for the petitioner, Mr. Amarendra Prasad Rai for the opposite party. But Mr. Somnath Mishra insisted that it should be kept pending. And in some matters, I have issued direction that let the amnesty scheme be forwarded to the petitioner. Where they say amnesty scheme we have not issued. Because these are the matters
We have noticed. They have given notice.
no, this can be disposed of in by amnesty or mediation. If both the parties agree, these are the nature of compliance. This mediation for nation can be worked out here.
Here.
I mean, these kind of matters, not in High Court. There should be effort.
Yes.
Yes. Mr. Satyanarayan Mahapatra appearance to likhi don, ठीक. Panel council किए जने थिले? Anyone for the Steam Union of India? आपण नो थिबी केना सकाळे मेंशन की करथिले
Union of India action.
आपण अछंती तो हां हां
I'm not appearing in this case.
you see the Mr. Srinivas Mahanti for the petitioner, Mr. Mishra, BB Mishra on behalf of so and so. But बुझी की तेबे
Government of India.
सेठी help करंतु. Helping the cause and the court also. You are officer of the court. So BB Mishra, senior panel counsel.
Yes.
On behalf of so and so, can say ताकर बारीक तो मिश्र लिखी देबे अपन सीजीसी थिबे कि जे भी थिबे ता नाटा सब लेबर ने
ଆପଣ ସେ ଆମେ ସର୍ଭ କପି
जानचंती कि मिस्टर महापात्र यूनियन के काउंसिल की मिस्टर Mahanti, any idea
about
the who was appearing for union? Who is that? Who are? Notice. So already somebody is appearing. Mr. Satyanarayan Mahapatra for OP number 2 and 3. So after disposal of the petitioner shall have liberty, the parties shall have liberty to work out it is there. You want to see that order, Mr. Mahanti? That order you want to see what? Okay. Yes, yes. Disposed of. Yes, next. Upon a day, Mr. Lekanga matter.
Item 23.
Mr. D.N. Lekka, AGA, for the petitioner.
This is another review petition, 328, 2019.
ଆପଣଙ୍କର lead case କୋଉଟା କହୁଛନ୍ତି ଦବା ପାଇଁ 328 ନୁହଁ 325 is the lead case ଆପଣ ଯଦି
ମୁଁ କହିବି 328 ଆଉରେ
ଆପଣ ଚାହୁଁଛନ୍ତି
28 ଟାରେ ନାଇଁ ସେ 28 ଟାରେ that has been condoned and on the prayer of the opposite party state that has been withdrawn with a liberty to file a writ appeal. Same all the 4-5 applicants
not maintainable. Writ appeal not maintainable.
But that has been the order passed by the coordinated bench of the Hon'Ble Court. I have also
wrong order. I have
writ petition ta ko order. Sorry, Mr. Khutia.
My lord.
So you have to tell me which order was challenged in the writ petition. Then whether writ appeal can
no order has been passed regarding regulation. I have prayed for regulation of my service. Before
so it is an administrative order by the single challenge before single bench or any other order?
No, any other. That is
so then innocuous appeal is maintainable. But yes. The problem is as you are saying that if there is a direction for consideration and they have not considered.
My lord. However, they have filed a review application.
So what do you want? Now the ball is in your court. it is good that you have opened the brief instead of because the order is to consider.
Yes, yes, my lord. They have
So
considered.
counter will file if you say today I'm not asking you to do that. If you can, you gather your thoughts, take instruction. This writ petition will be restored, counter will be filed and decided on merit.
Yes,
that will be the order.
Your lordship, may call it some other day. I will.
May I say? He filed a repetition for regulation of service.
नहीं आपनकर सीट 328 आपनकर 325
सब जगह.
Okay.
328 he said that has been withdrawn.
से कहूँ चलो. She was saying mentioning rightly so. she कहा था जे 325 ये review petition has been withdrawn. But withdrawal of a review petition is also not a binding precedent.
Not yes.
If you wish that I will pass a order since the other review application has been withdrawn because this is another writ application.
Yes,
This writ
another.
petition is a separate cause. Please appreciate. Yes, it is not a batch. Yes.
No, not a badge, but similar.
Yes.
Similar.
Now please hear Mr. Lenka.
Yes.
You can take your seat. No difficult.
The present review application arising out of a writ petition number 4735 of 2029 disposed upon 18/3/2019. At the time of admission,
Mr. Lenka, I got your point. Can I interrupt you?
yes,
Let us assume that your case is that the court did not consider on the second date itself, without there being any pleadings or assertions by you controverting or accepting, it has been done. It's just possible that you would have accepted the prayer and said that we are accepting and let the writ petition be disposed of. That is your point?
yes, admission phase.
Correct. But now suppose can I take up this matter on merits? If I take up, then you are losing a forum and he is losing a forum. Both of you. Because in the review petition, the reviewing court does not have any material as far as pleadings is concerned to pass a order on merits, which is your grievance. And Mr. Bhuya also fairly says that was the order. That no observation on merit, but in the light of so and so judgment, he shall be considered. So you are saying that there is some difficulty in regularizing him.
Yes, there is no sanction post. That is the whole.
Sir, whatever, but those facts, how can I now say by the review application? Because now suppose your ground is that you filed a counter, there was no sanction post, or there is sanction post, all posts are filled up, and the court did not take that into account. That is a ground of review.
Yeah.
But here is a case, there is no material available on record for the reviewing court to do anything.
But here is a case.
So ideally, Mr. Lenka, it should go to the single bench for completion of pleadings.
Remand.
Remand, strictly, I cannot remand a single bench matter. But if you both of you agree, file that memo, that order, to that extent I'll review. I have review power in absence of the earlier honorable judge. Even I do not have the review power also, being a coordinate bench. But after retirement of the honorable judge earlier, so the review has been posted before me as it is my roster now. My determination, subject determination. But if you say that I'll observe that there is no sanction post, I don't think that's a correct approach. In absence of, so now suppose you say there are no sanction posts available on the date.
Our case.
He will now say, file a rejoinder. Those things cannot be permitted in a review.
As your lordship.
He has to agree to that.
He has filed the counter. He has already filed counter in this area.
Counter in the review is the petition. You have to file counter.
And admittedly, last 18 years they are working.
You file a joint memo. That would help both of you. At least you will not be feeling deprived of opportunity. He will not be feeling deprived of opportunity by arguing a review application. I will be considering the matter on merits. That is not. It will be restored and it is listed as per its assignment. Could be the same judge. Yes, Mr. Bhuya. You have heard Mr. Lenka. How do you overcome that?
That means admittedly, there is no scope of review because your lordship knows.
That's not that. They are saying that on the second date itself, the matter is disposed of.
My lord.
Without adverting to the facts. In case of a regularization, if you see the law, again and again, our court, Supreme Court, they have held that there has to be a completion of, complete analysis of conspectus of facts. So and so post, eligibility, and conditions of filling up that post have to be considered by the court.
My lord.
Because it is our job to adjudicate.
My lord.
We will allow your prayer. They are aggrieved. They will file writ appeal. We dismiss the writ application. We in the sense, the court. We dismiss your writ application. You file a writ appeal. But in review application, you are saying arguing on merits. In fact, unwittingly, you are also arguing on merits in review application.
I am arguing on merit. In review, they have no scope. There is no scope of review for this. Limited scope, your lordship knows. That they have not also.
Recalling a order is also a review. That is what I am trying to.
Yes, that amounts to review.
It's upon both of you.
Yes.
Both learned counsel, you have. I mean, you are sufficiently both of you. I'm regard. So that is how. So restoring the matter for consideration on merit. One thing that Mr. Lenka, you have to file the counter within a time stipulated.
Your lordship may target.
Target then. The High Court coordinate bench is a district judge. I will target his matters. That I cannot do. Obviously, you will file the pleading should be completed. Then it is for the court which will be assigned of the matter. It will take up the matter. You file that memo.
Similar position again. On one side already regularly.
I have to reject your prayer. Similarity in position has to be factual.
Factual aspect.
You are contradicting yourself.
That factual aspect.
You should have allowed the petition to be decided on merits. When you can argue this? When the pleadings are complete.
Instruction accordingly.
Next week the reason being that matter to merit argue cover like the 1,000 matters, about 600 I have disposed of in division bench. Will be remanded by the Supreme Court. You must understand what is happening. After 10 or 15 years, the matter had to be heard again by the division bench of this court.
Yes. And
So you have contributed. With some responsibility, I am saying. You should have allowed the pleadings to be complete, matter decided.
Within a specified period.
Then if they are unhappy, they will challenge.
Either way.
Yes.
Next again,
the learned AG was heard at length, and so also the learned counsel, Mr. Khuntia. Upon appearance, Mr. Pradeep Kumar Khuntia for the opposite party. The learned AG was heard at length on behalf of the review petitioner state. And so also the learned counsel, Mr. Khuntia for the opposite party. It is submitted by the learned counsel for the petitioner that RBWPT quota would rela 328. The learned counsel for the opposite party, who was the petitioner in the writ application, that RBWPT 328 of 2019. Yes. 328 of 2019 has been withdrawn. I believe, sir, I have to simply reflect 2 lines on that. Your submission I am recording. 328 has been withdrawn.
Order date
for consider stop. It is submitted before consideration of the review applications in the present batch. The said aspect need to be considered by this court. The learned AGA submits that all the review applications are separate, seeking review of different orders passed in different writ applications. Withdrawal of a particular review application would be of no avail, as contended by the learned counsel for the opposite parties. Referring to the merits of the review application, it is submitted by the learned AGA that the writ application was disposed of by the learned single bench, by the coordinate bench of this court, without delving into the facts of the case or merits of the contentions raised by that was to be raised. That the file that was to be raised by the opposite parties by filing counter. The learned counsel for the opposite party fairly submits that counter was not filed, but similar orders have been passed in several cases. It is submitted by the learned AGA that for issuing a direction for regularization in particular post under the government or in an entity that is state under as defined under Article 12 of the Constitution of India. This court exercising this jurisdiction has to consider the facts such as availability of post, eligibility of the candidate, financial capability, and the cadre rules regulating the employment.
And nature of engagement also.
Nature of engagement. It is submitted that without the pleadings being there on record, these aspects could not have been brought to the notice of the coordinate bench when the matter was considered and finally disposed of on the fast date, the second fast date itself. So, para, it is not disputed that on the date of first listing of the matter, after it was presented, on the date of first listing of the matter, dated on 18/3/2019, after it was presented, on 22/2/2019 before the court, the writ application was disposed of. Today, observe, Mr. Khuntia, or you will after you obtain instruction?
After instruction.
Okay. The learned counsel for the opposite party has adjournment to respond to the submissions of the learned AGA, seeking review of the order. List for orders in the week commencing in the 9/2/2026. The February and March dates are identical, so that is creating confusion. It starts on Sunday, both start on Sunday, and yes. तापर लिखंतु RBWPT 327 next sub item बुझछन्ति 327. The matter was heard along with RBWPT 325 of 2019. Stop. In view of the order passed in the said RBWPT list, it shall be listed along with the RBWPT 325 of 2019 in the week commencing 9/2/2026.
There are 3 connected cases.
सबुडे अलग अलग ऑर्डर 326 गला 26 रे जा ऑर्डर 27 रे से ऑर्डर 33 रे से ऑर्डर अब केते मिस्टर भुया अछि अपन गाव केटा अछि गोटे विथड्रॉ हे जी यस नेक्स्ट So we have to be little bit patient. आपण जो impatient ହେଇଯିବେ ଲୋକ ତ ବ୍ୟସ୍ତ ଆପଣ ବି ବ୍ୟସ୍ତ ହେଇକି fast ମାନେ ମାସେ ଭିତରେ dispose of ହେଇଗଲା. That will lead to a situation when after goes to Supreme Court remands it, again it has to be considered.
ତାହେଲେ ଅଲଗା ଏମ୍ପ୍ଲୟ ମାନେ
ସେଇଟା Mr. Samal, Mr. Ranjit Samal, he files cases in hundreds, thousands.
ଆଜ୍ଞା
ଆପଣଙ୍କର ତ same problem. You never know when you will stumble and fall apart.
କିନ୍ତୁ ସେଇ ଡିପାର୍ଟମେଣ୍ଟ ଅନ୍ୟମାନେ
Somewhere in all matters they not challenged in Supreme Court.
No.
Then
in similar order, similar employees, they have been regularized. That is the problem.
से निजी ताको से रेकॉर्ड को ऑन बिहाफ ऑफ करिबि न अब 28 सेकंड में अच्छा यस डॉक्टर पड़ो ऑर्डर नोट के Younger Mr. Gupta has left. Where is he? नाटा कौन की गुप्ता अरे तांको ज्योतिर्मय गुप्ता सीनियर को ना तांको पुओ को ना कौन रे
$25
क्या अपन को जे सीरियल देखना थी अच्छा सॉरी यस मिस्टर
मेंटेनेंस केसटा टाइम नबार
तो मिस्टर दास whenever I am not passing any orders recording adjournments I am saving time by that so आपण केबे गला कोंतु 23 2 की जाई मैं ऑलरेडी ताक रिक्वेस्ट कर देई मिस्टर बारी गिव अप रेस्पॉन्ड 25 आइटम 25 से 55 केबे गला
will commence 23
23 ना केते करछ 23 2 कर दियो ठीक है 23 2 कर दियो
मेंटेनेंस टा दोना तो
सेगा आपण जतो हस्बैंड टा अपेयर करछन आपण दोना आपण तो इलाबोरेट सेटा केशवानंद भारती वाज आर्ग्यूड बाय फॉर द हस्बैंड फर्स्ट मैटर जब सुनले ना नहीं सेटा थर्ड टाइम केशवानंद भारती 24 रे कौन स्कोप कौन ये this whole litigation scenario has become really haywire. It has gone haywire, almost aimless and objectiveless.
26 already complied, man.
Yes he mentioned that but I forgot his name so I was Mr. Gupta's son, younger Mr. Gupta.
JK Gupta.
ज्योतिर्मय स्वामी जेके
नहीं ये तो जेके तारो वाला जाने
से बुझी लिखिबे कोर्ट मास्टर बुझिबे to submit Mr. DN Lenka AGA for the opposite party. It is submitted by the learned counsel for the petitioner that as per the instructions received the order has been complied. Order dated 23/11/2021 passed in WPC number 33009 of 2021 has been complied with.
And compliance affidavit dated 31.
The AGA refers to the compliance affidavit filed by the opposite party director secondary education dated 31 January 2026. To submit that the order has been complied with. The compliance affidavit is accepted. The petition is dropped.
Yes. Lovely.
Call करो तू.
Item 30.
29 आपण सर की कॉलिंग अर्जन कर दीजन सेगा जोथरे आपनकर दिया जाउची मेंटेनेंस से आगो अर्जन कर दोछन
नहीं मेंटेनेंस नहीं कस्टडी तो चाहिए
से है कि कस्टडी जे अपोज करछन से जहां का पाखरे अछि yesterday that happened
ମୁଁ ତ ଅଛି
कौन करे से तो आपण को इन्फॉर्म करे कथा
ମତେ ଲୋକ ହିଁ ଟାଇମ୍ ନାହିଁ
नहीं यू आर राइट गुड राइट
କେବେ ଡେଟ୍ ଫିକ୍ସ ହେଇନି
केबे को डेट बिछन आपण जेबे चाहिए आई रिकॉर्ड द पिटिशनर को नाम लिखछन कि और मु लिखुनी बोले आपण लिखिबे मिस्टर गिरिजा शंकर नायक for the petitioner, Mr. Satyavadi Mantri for the opposite party. When the proceedings started, when the day's proceedings started, the learned counsel for the petitioner mentioned the matter to be adjourned. When the matter reaches, it is submitted by Mr. Mantri, learned counsel for the opposite party, that he was not informed regarding adjournment of the matter. Stop. However, the matter is adjourned to be listed in the week commencing 23/2/2026. Next. Call करूँ तू.
May I please, Your Lordship? Your Lordship, I am for the petitioner, wherein
other side.
Yes, I am a petitioner.
Gucci asunto.
Actually, the petitioners for this one. Herein, the petitioner has filed this. Petitioner has filed this petition for transfer of the DV case, which criminal miscase, which is pending before the learned JMFC Pipili. Here the story is, my lord.
No. Go by law, sir.
So
don't again make it another. We have already finished Keswaranda Bharati. Now you'll argue A.K. Gopalan. Sir, what is the law? What is the law on this? Straight away go there.
I'm coming to the brief of the brief facts.
On transfer matters, what is the scope of judicial interference when the husband wants transfer?
Here the case is the husband has died and the case has been made against the father-in-law. And father-in-law is having many critical ailments, and he's a person who is unemployed and is dependent on the government pension scheme. And other 5 respondents who are the mother-in-law and 4 sister-in-laws.
Only go to the Domestic Violence Act. Straight away come to the section which provides for the jurisdiction, territorial jurisdiction.
I'm so sorry, my lord. I forgot that act.
Never do that. Sir, always be crisp information.
So sorry.
Straight away come to the point that this is the scope of the territorial jurisdiction, where it should be filed. What is the section? Then you go to the point that in which cases this court can interfere, or there can be an error apparent in jurisdiction. Can be. So that would be your first point.
Yes.
That the case should have been filed at Sambalpur as per the statute, but it has been filed at Bargarh. So that way, that is the simplest form of, yes, what do you say, Mr. Saman Singh, old man? Old man, you are young enough to prosecute your father-in-law.
Yes, sir. Father-in-law.
You are 26, he is 62.
60 to 70, respective year.
72.
Only the paragraph they have taken in by paragraph 6 that they are not physically well to attend the court.
Definitely.
Recently, the Supreme Court has said in 2025 judgment is there. The physical appearance of the party is not required in the domestic violence case.
That is the secondary part, ICT. That Sir, those orders are passing, but Supreme Court did not consider the case of a 72-year-old. The judgments you are referring, Supreme Court did not refer to the case of a 72-year-old person.
72 କଥା କହୁନି ଆଗ ଗୋଟେ ଜିନିଷ
ସେମିତି generalize କରିବୁନି. Whenever you start generalizing these things, it creates difficulty for adjudication also. If I will not consider the contention is that I'm an old person having ailments at 72 years, you are giving a general statement that not necessary. So you have to show in case of even in an elderly person also, the case the Supreme Court has said that it need not be transferred. Fair enough, you make that point.
No, it is
I beg your pardon. Don't change the facts and all these things. That's the problem.
Actually, it is a quasi-civil and quasi-criminal nature case. Domestic violence.
How many transfer applications are filed in civil proceedings? More or criminal matters? According to you, for transferring applications in general, the petitions filed for civil matters is many times more than criminal matters. So obviously, quasi-criminal, obviously it has to be taking color of civil proceedings. That is how TRPC, not TRPCR, or it's a TRPCRL. TRPCRL, okay. So it's a quasi-criminal proceeding. So same principle will apply where it applies in civil proceeding.
Criminal proceeding, it only attracts after breach of order is violated. When the breach of order arises, then the quasi-criminal criminal provisions will attract. That is section 28,
28 of? Section must have an act.
Section 27 completely says that the jurisdictions. That is the jurisdiction, DV Act.
23-2 petition has been filed by you?
Yes.
He wants transfer of a 23 petition.
23 petitions.
So in what circumstances 23-2 petitions will be transferred? That I asked. So is it your contention that a 23-2 petition cannot be transferred? I could not follow your proposition.
No.
23-2 petition cannot be transferred. Day in, day out, they have been transferred.
23-1 is the interview.
Sir, 21. Yes, I stand corrected.
Yes.
21 petition.
12
petition.
12 petition cannot be.
So I am showing symptoms of fatigue and your contention, if your contention is section 12 cannot be transferred.
Cannot be transferred.
So straight away come to the case law because section 12 transfer is most sought after now in it is replete with all courts.
The section
125, section 12. The courts are, it is flooded with litigation for transfer.
Lord, so kindly come to section 27, which describes the jurisdiction. Jurisdiction itself.
First make a legal submission.
Okay.
If you are saying section 27 is a bar for transferring 12,
yes.
So I will assist you.
Okay.
So you tell that so that he can respond. 27 is a bar according to you.
Okay.
Yes.
27 bar 6. That first, the court of judicial magistrate of the first class or the metropolitan magistrate, as the case may be, within the local limits of which the person aggrieved permanently or temporarily resides or carries on business or is employed. This is fast. It attracts millets. It is my favor, Miller. Because the agreed person is the
don't interrupt the section by your speech.
No, sir.
Complete the reading the section, sir.
Yes.
I cannot take cognizance of your reading.
Yes, B Miller, the respondent resides or carries on business or is employed. Or C, the cause of action has arisen.
So
shall be.
So here where from where to where transfer is sought for?
Again.
कोठू के ट्रांसफर करने पे चाहे पिटीशन फाइल इसी
सी बगैर पिटीशन फाइल करछन फ्रॉम प्रिपिली टू केंद्रापड़ा
हां काइंडली रीड बी
हां द रेस्पोंडेंट रिजाइड्स और
what do you mean by the respondent resides?
Respondent resides at Kendrapada.
So then you are arguing for him or for yourself?
No, myself.
No. Then how you are citing the provision which he should rely on?
No.
27B is explicit.
Yes.
It has to be filed at a place where the respondent resides. The respondent is 72 years of age, ailing, he has difficulty. So how are you saying that 27 is a bar?
27.
You see, since you are reading 27A in isolation, right. Then what is your interpretation on 27? The respondent resides.
27 only says the jurisdictions. First, The jurisdiction is the
Sir,
aggrieved person.
Sir, if we jump around from one topic to another, you are saying 27 is a bar for transfer of the petition. So we read, both of us read. You have assisted or enlightened me. 27B is very explicit, where the respondent resides. So what is your answer to that? How the transfer petition is bad?
Because Miller, what other hand the fact, lots of people go to the factual point. The aggrieved person is a widow lady. She has no means to attend the court at the Kendrapada.
How can I say that? How can I say that? If the statute says that 27B is explicit and also very clear, can there be any two? You see, you read 27A in isolation. I cannot read like that. 27, the widow, widow is seeking to enforce her right.
Yes.
So the respondent doesn't have any right under 27B.
That is a secondary, Miller.
Secondary, if you say, then you have to cite a decision. May not be that big as Keswarananda Bharati, but you have to. We don't have the freedom. You and me, both of us, cannot, dismember the statute. We'll only read 27B. When we read, we'll forget that it is not a good thing. Sir, if you are relying on 27A, he will rely on 27B. Now comes a case of competing equity or competing rights and claims. How can I say that 27B cannot be read?
In this, the decision of this honorable court also, the convenience and inconvenience of the wife has to be paramount consideration.
Straight away come to a decision where 27B, despite 27B, the court says that it cannot be entertained. Straight away come to that. I have been requesting you on that. You have to elevate your. Our discussion should be more substantial. The emptiness should not be this much.
Okay.
Like I was requested that I will lay down law, despite the Supreme Court decision. That should not happen. If you have a case law on this, that 27B has to be ignored. When a lady is filing a matter, so then you have to bring that on record. At least let us discuss on that.
Lady, no means at all, widow lady and having a minor child, 2 years old. It is just impossible to attend in the distance place.
Wherein the petitioner is he has only son who was only earning person in the family. He died. After that, they claim all the remaining whatever he has, like insurance, everything laying in the bank account. In legal hair, all the three names were there. The petitioners.
That is law, sir. You cannot have a grievance as far as operation of law is concerned. Class 1 legal hairs getting everything is the law. They are class 1 legal hair. And if you have any kind of claim as far as the estate of the deceased, this is not the proceeding.
I'm not coming to that.
The Domestic Violence Act is different. In fact, though Mr. Shaman Singhar did not say this, 125 and 27, they are similarly worded. 126. Look at 126. Dion. Bharatiya Nyaya Samhita Dion.
So I have that.
Bharatiya Anchati. 145. 145. 145 Bharatiya Nyaya Samhita. ଆପଣ ମତେ ଭାରତୀୟ ନ୍ୟାୟ
BNS.
अरे नोन तो कहा कहीं गपुଛ ବହି ପିଲା ପରେ ଫେର କଣ ଅସୁବିଧା ହେଲା ଆଉ ଗୋଟେ ଦରକାର
BNSS
ନଉନାହାନ୍ତି ଆରେ ଏଇଟା ନଉନାହାନ୍ତି ମୋ ପାଖରେ ଆଉ ଗୋଟେ ଅଛି ଆରେ ଏଇଠି ଅଛି ଦିଅନ୍ତୁ ଏଇଠି ଦିଅନ୍ତୁ ଏଇଟା
Procedure.
ଦେଖ ହଁ ବହୁତ ଅଛି ବହୁତ Nagariko Surakha Shweta. I stand corrected.
Be necessary.
Yes. Can you read? Now, just read what Mr. Samant Singh has read 27.
145.
145.
145, the procedure subsection 1 says proceeding under section 144.
Slowly, not this fast. You will miss the words. Yes.
Proceedings under section 144 may be taken against any person in any district where he is or where he or his wife resides or where he last resided with his wife or as the case may be. With
So for this D,
where his father or mother resides.
So now look at again 27, read 27 again.
27.
Yes. Mr. Samant Singh, can you lend your book? Yes.
The jurisdiction part, my lords.
Yes.
The Court of Judicial Magistrate of the first class or the Metropolitan Magistrates, as the case may be, within the local limits of which the person aggrieved permanently or temporarily resides or carries on business or is employed.
So if you compare with 4145, where he or his wife resides, so this is for beneficial legislation for a lady. So my interpretation, I have been disposing of referring to 145. I am not allowing any transfer of 144 petitions. 144 is 125. 125, 126 CRPC. Now 145, 144, 145 BNSS. I have not passed to. How can I deviate from my orders? Because now here is a case what I was trying to tell Mr. Singh. 27B and 27A. So 27A says person aggrieved resides. Person aggrieved resides. B respondent resides. So if Mr. Samant Singh's argument is in the extreme, he says that B should not be looked into. Obviously, B has to be looked into. After looking at B, now there is a competing equity where the widow lady with her child stays or the person who says he is elderly. According to then I think it has to tilt in the favor of the lady. She will be facing much more difficulty.
In the other hand, they will be facing more. They are facing, my lords, because they are having just recently has been met with an accident and there is no one to take care.
Accident is not a proviso.
He is not.
What's your name, sir?
Lokesh Gaurav Maharana.
Lokesh Gaurav Maharana. Mr. Maharana, if there is a proviso in case of any accident to any of the parties, the matter should be posted to that court. Those exigencies of nature, if I start recording, then all of you will laugh at me.
In that petition,
there has to be always be strict in your presentation as far as law is concerned. Sir, for that you seek a adjournment. Court refuses, come here. Mr. Samant Singh argues, I will grant adjournment. But you have to now address me that if there is a competing claim between the lady who is widowed, 26 years of age, with a small child, and the statute empowers her. The statute gives her the scope to file where the person aggrieved resides. So they might have something unfortunate has befallen on them.
So in the petition, they have all the incident happened in Pili. All the incidents happened in
27A. 27A, that's the problem. Because in 125, now 144, the similar arguments are made. That everything, because you see the legislature is not, can you say that legislature did not consider a destitute lady is most likely to stay where?
Parents' home.
Possibly. It can be brother's place. But definitely not the matrimonial place. Because she's already deserted. So that is how the legislative intent is that wherever she stays, she will file. Otherwise, the norm is the cause of action. So why do you find in 27 cause of action arises?
Cause of action C.
Yes.
27C.
So then why not is in BA? Can you, then your problem would be you are reading C in isolation. Mr. Samant Singhar is reading A in isolation. Similar provision in 145. Just now you read 145.
Yes.
No, cause of action is not there. That provision is not there. So, I mean, why then? Why the cause of action is the last entry in that list, in the section? Here, the statute the legislature has created that.
So the petitioner, like the widow lady, she's staying at Jatani.
Then you have to distinguish also, though I have not looked at this.
Because the
Rabindranath Sahu versus Sushila Sahu, 2016 Criminal Law Journal, Orissa. That favors Mr. Samant Singhar's argument. Just footnote case law
27.
हाँ 27 आपण एटा धरछन्ते ना नहीं को बइटा ए बइटा हाँ सिमिलर कमेंट्स से देखंतु कमेंट्स से देखंतु तार से जो केस लड़ा अछि देखें.
This section lays down that the magistrate within the local limits of whose jurisdiction the aggrieved person permanently or temporarily resides or carries on business or is employed.
So stop there. So it is enough. The aggrieved person temporarily, even temporary, because see what I was telling you. After becoming a destitute or she is driven out or whatever reason she is not pulling well, she leaves the house. So that is how the law protects her. That she will be given financial assistance at her place of residence, temporary or permanent. Then kindly read the case law.
Case law, on clauses.
Section 98
case laws. Yes, here it is.
Kindly read it aloud so that I can know what you are reading.
Jurisdiction under which a case under the Act can be filed, where the aggrieved person resides, either temporarily or permanently, the court of the JMFC, under whose jurisdiction the said place situated is competent to entertain an application under Section 12 of the Act and to grant protection order or other orders under the Act or to try the offences under the Act.
It is very reasonable, though you are not arguing that extreme, but it is reasonable. I mean, the court having jurisdiction where the person resides, and that is entry A. So I am disposing of it as it has been stayed.
Stay was not allowed, but till date, like this week only, the stay was there.
So I am disposing of it. But obviously ICT facility, whenever you make an application, it has to be considered because you have to tell that I will not appear, I will appear through VC, I will appear through that deposition file. What is that called? Deposition, deposition center. VWDC is also utilized for deposition of others. Deposition that camera facility is there.
So for the same reason only, they have been expected twice. They have paid a cost of ₹2,000 for not appearing for a single day.
So what would have happened if it is transferred to the place Kendrapada and it gets dismissed for non-prosecution by the lady after the court directs? Assume. Now it is transferred to Kendrapada. Then what would happen?
There are 6 numbers of respondents.
It is always a case of competing equities. It can't be isolation. And the statute has a purpose.
So there are 6 number of respondents in the DV Act. So one resides in Bhadrak, one resides in Jajpur, one resides in Nischint Koili. So they are 100 kilometers far from from Pipili, it is very difficult for them.
Where is that proviso? The distance of the location of like SpaceX. Nowadays SpaceX people are going to space. So one is suppose an astronaut. Where is that proviso? How can I interpret that way? The purpose is there. There is a clear-cut legislative intent that the lady where she sees, the nearest place, she should get the redressal of for requirement of financial assistance.
So financial assistance, she went to withdraw all the money, and she asked NOC from the father-in-law and mother-in-law. So they told, yes, you may take, but you at least you stay over there. We don't have, only son was there, and out of that only one male child is there. So our everything is that child only. So she went to withdraw all the money. They have moved for one civil suit, restraining him from withdrawing the money. After 6 months, this DV case have been filed. And she has,
do you know who asked her to file the DV case? That you know. So these are all, this personal laws and this matrimonial and DV Act, it is being utilized for many other purpose other than what it is meant for.
And this,
so what can be done?
And this is
where the court has no role. Those things cannot be. What you are saying is correct. These persons, so even she was advised looking at the advanced age of these litigants, your clients, she has been advised that you do a DV case, they will let us see what they are doing. And you should not also, in your part, where she is entitled as class 1 legal heir, look for a share in her fortune. Because she is already unfortunate to lose her husband.
So that civil suit
being a class 1 heir, if you are filing, pursue the civil suit and restrain.
Civil suit is disposed of.
It has to be. It has to be, because a class 1 legal heir, you cannot have any claim over. That is again law.
They were not challenging
that is again law.
They were not challenging to take the money. They were only challenging that don't take our money. We are also entitled for
under
our sons.
Under which law? She cannot take your money. It is impossible. You have been given that impression. If a client comes to you and tells that she has taken away her money, nowadays these are not possible. Because there is no consolidated. If beneficiaries are multiple, they are making it separate. Whatever LIC, whatever everything, when she is the nominee, she is entitled. You are not the nominee. She cannot. Suppose house building, he has got. The house building she will get, not you.
So we don't have any objection to that.
So we objecting and filing cases, civil suit, that has resulted in Mr. Samant Singh advising her to file.
So that thing, civil suit is only for not to restrain him.
It is easier to identify because he is in front of me. So this goes on.
So civil suit is only to restrain him from taking all the money. And the prayer also is there.
I have been asking you, this is for the third time asking which money you are saying, not all the money.
Bank account. Amount laying in the bank account.
Bank account, in the account where she is the, that is called a joint account, either or survivor. The bank money, savings bank devolves on the legal heir, class 1 legal heir. It doesn't devolve on the parents. It can. So all the money after the unfortunate incident of demise of the son will go to the wife. The bank will be at real problem if they give it to the father or anyone else other than the legal heir.
Our prayer is to divide the money within all the legal heirs.
Who will divide?
The authority.
If they have any claim.
Legal heir, class 1 legal heir, have you checked the list?
Class 1 legal heir is the
wife. You must understand, any bank account is it agreements also. The bank cannot distribute to parents and to persons if the human being before dying he liked. Bank cannot do that. And suppose there is a legal heir certificate in your favor. Let us ask you.
It is not in my favor. The petitioner number 1 name is deleted from the legal heir certificate.
It has to be. They are actually, you have misplaced your demand. Are you sure that she is claiming any share from your property? She cannot. She will only inherit through her husband.
Husband, sir.
Or strip per capita. So the law is very well settled. These are. They are thinking agreed for nothing. So, they are feeling agreed that all the savings bank account money she has taken. The LIC she has taken. That cannot be. They should not feel aggrieved. It is unfortunate. Maybe they can have a grievance that Our son has
Nothing
kept
is-
all the money in name of his wife.
One loan is also pending and the nominee is the petitioner number one, the father-in-law. 7 lakhs they have to submit. They're getting demand notice from the bank.
What can be done? For that, they have to feel bad. But that's not illegal that they will ask the wife. If the wife is good enough, she may repay the loan. That's another thing.
So at least to Cuttack,
No. Here, the 125 principle has to apply. I have already held. If my order is set aside by superior court, then it's a different thing. Because I have to follow 27A.
so the court below is the,
If 27A, B, C is not satisfied, it's a lack of jurisdiction. And the purpose of making the person aggrieved is that she has to have legal remedy nearest to her. So, set up to 125 order, add kar debe. This is item 30. Mr. Lokesh Gaurav Maharana for the petitioner. You please take your seat. I'll take some time in dictating the order. So Lokesh Gaurav Maharana for the petitioner, Mr. Ratnakara Samanta Singhar for the opposite party. Mahuda Gadantu jaha detu. I would the petitioner is the father-in-law of the opposite party. The application has been filed for transfer of has been filed under section 447 of the Bharatiya Nagarika Suraksha Sanhita into bracket BNSS, 2023 for transfer of criminal miscase number 41 of 2024 from the Court of Learned Civil Judge Junior Division -com-J.M.F.C. to the Court of Learned Additional Civil Judge, Junior Division -com-JMFC Kendrapada. Before the learned opposite petitioner copy that file करना है petition copy that कितने page file करना है
go copy
ଆପଣଙ୍କର ଯୋଉ ଆପଣ ଏଇ ଯୋଉ TRPC ଟା ଫାଇଲ କରିଛନ୍ତି ପିଟିସନ ର କପିଟା ଫାଇଲ କରିଛନ୍ତି
petitioner copy is not there in there.
Okay.
Protection.
Yes, got it. On लिखिए
Protection.
Before the learned JMFC, sorry, the learned Civil Judge Junior Division. The criminal miscase was filed under section 12 of the Domestic Violence Act.
The wife has filed a application before the protection officer, and that protection officer, after inquiring the case, referred directly to the court.
Then you sentence. Before the Lord Civil Justice Division, full stop kare. Was initiated. File number according to was initiated after the protection officer under the DV Act has forwarded. So
DIR, domestic DIR report. DIR.
Domestic inspection report.
DIR.
Into bracket DIR. After the complaint on behalf of the opposite party daughter-in-law was filed before the protection officer. Quick interruption. Mr. Mishra, you are the counsel there. You will be recorded as counsel. That Union of India.
That 28 item.
No, you have. Could you get the name of the counsel who is appearing?
It is not in our list chart today. So I have to inquire from the office. I will inquire if any other.
So then you inform the court master.
Accordingly, I will.
But your name has to be there because you were present. I have recorded that, but on behalf or along with you can say. Yes. On the transfer is sought for by the opposite party before the Learned Civil Judge Junior Division. All the opposite parties are seeking transfer. Plural by the opposite parties. So, the learned counsel for the petitioner and as well as the opposite party were heard at length. It is submitted by the learned counsel for the petitioner that the petitioner number 1, father-in-law, is aged about 71 years. And petitioner number 2, mother-in-law, is aged about 67 years. Though the other petitioners are aged the other four petitioners are aged in between 44 and 35 years. So it is submitted that the petitioners number 1 and 2 are facing difficulty in attending the matter at Pipili. The learned counsel for the opposite party refers to the Section 27 of the Protection of Women from Domestic Violence Act, 2005, and relies on subsection A of Section 27, subsection 1 in English one, subsection into bracket 1 into bracket small a of Section 27. The learned counsel for the petitioners, plural. The learned counsel for the petitioners relies on Section 27 into bracket English 1, then into bracket small b. For convenience of reference, the said Section 27 is reproduced herein. In the case at hand, the submission on behalf of the petitioners who are the opposite party in the DV case before the learned judicial magistrate is correct to the extent they are aged, for which they would be having some ailments and limitations in attending the matter at Pipili. Stop, Sopara. Simultaneously, the legislative intent of indicating the jurisdiction of initiation of the case to be the local limits of which the person aggrieved 27 এটা রিপ্রোডিউস করে দেবে ওর উপরে করছেন মার্জিনে 27 এ লিখ limits of which the person aggrieved to make it employed. It has to be noticed that the entry in the jurisdiction clause gives a preference as far as the place of residence of the person aggrieved is concerned. The preamble of the Act 43 of 2005 indicates the following. So the preamble of the check kar debe. To the recital, so that may be the recital, short recital, I think. Preamble of the Act 43 of 2005, notified on 13th September 2005. Act जो लिखी नहीं पूरा ना लिखी देवे. The Protection of Women from Domestic Violence Act, right? An act to provide for more effective protection of the rights to of women guaranteed under the Constitution who are victims of violence of any kind occurring within the family and for matters connected therewith or incidental thereto. The definition section, that is section 2A, defines aggrieved person and B defines child. The said section, the said definitions are reproduced herein. In considered view of this court, to give full effect to the legislative intent in section 27, read with the recital of the Act and the definitions 2A and B. Section 27A has to be given its full meaning, and herein the opposite party, being a widow, being a young widow, staying with her child at her father's place at her paternal home bodhe. Now not sure.
Not sure.
Staying at a place which from the address given indicates that her paternal place is at Delangopuri.
Village.
Therefore, in considered view of this court, the prayer made by the opposite parties
she has given her address. The protection officer has given her address that parental house form number से जो annexure କରିଛନ୍ତି
ସେଇଟା ପେଜ ଟା କହିବେ ନା ସାର୍ ଆପଣ
page होती 19 ଟା
page 19 लिखते हैं page 19 लिखନ୍ତୁ the protection officer has given her the address of the lady which forms part of the report nahi ki
part of the report
which forms part of the report as annexed to the writ application annexure 1 সেটা কোট করে দেবে দৈতারি মহারাণা নাকি ডক্টর অফ নাই নো সেটা দৈতারি
ডক্টর
ভগবান ডক্টর অফ ভগবান মহারাণা পুরোটা লিখিবে ভগবান মহারাণা ভিলেজ পোস্ট ভাইয়া PS district page 19 ରେ ଅଛି ଭଗବାନ ମହାରାଣାରୁ ଆରମ୍ଭ କଲେ ହେଲା in view of the above discussions the prayer made in the application for transfer of the petition filed by the opposite party wife cannot be acceded to
petitioner
sorry so the prayer made by petitioners for transfer of नहीं अब तो पूरे पढ़ो ताले filed on the petition initiated pursuant to the report which was in turn pursuant to the ସେଟା କମ୍ପ୍ଲେନ୍ କୁହାଉଛି ନା କଣ କୁହାଉଛି ୱାଇଫ୍ ଯୋଉଟା ଲଜ୍ କରୁଛି
application
pursuant to the application made by the opposite party wife cannot be acceded to at the instance of the opposite party in the proceeding so then that ICT paragraph ta rahega whatever if you want I mean since they are taking into view the fact that petition number 1 and 2 are elderly persons and the other opposite parties stay at different locations ICT paragraph if any application is made for providing it but you have to make that application যদি আপনারা video conferencing and all that use করিবে you have to make that application yes the petition is disposed of accordingly. Yes. Next. 32. Since I have other engagement, so I have to rise. So rest of the matters.
মোটা যদি অর্ডার রাখছনা সরজান from the date of application জায়গায় from the date of order ହେଇଛି
30 number item 33 কেবে অর্ডার আনি পারিবে 33 पर ऑर्डर्स कर दियो
এই কোটে গিরবা তা কিছু নাই
তে আপন যেতবেলে ধরন্তু আজি আমি পਹੁঁচিলে কো যায় 32 so 33 টা আপন তळୁ কেমতি ଯିବ উপর গ্যাস করিবন कंप्यूटर को শুনুনি আপন कता को लेफ्ट ओवर करिवे ना को लेफ्ट ओवर फिर को डेट रे जीवो से पर आउरी प्रॉब्लम है की
ऑर्डर्स राशि रहता
ने आपण अदर सीट
जानने के जानी नहीं 33 ऑप्शन
ना 32
ये 33 कौन कहउछन
माय नाम 32 हम 32
31 अर्जन है
33 अच्छे तो
33 मिला
हां
कॉपी नॉट सारू अपन मी
रोकी गई थला
नहीं देखो ना फर्दर जाके अच्छे आप कुछ नहीं मो पाखरे
ये तो लोग खुद ही करी दी तो
नहीं
ये लोग चक्रवर्ती
से
कॉपी दे दियो
आउट दे दियो तो 33
ଗୋଟେ ଲାଇନରେ ସାର୍ ଯଦି
32
ଅବିକା
କରୁଛନ୍ତି ଆମେ
ଅବିକା ବି କହିଦେଲେ ସରିଯାନ୍ତା
32 I am for the opposite party. The notice had written back to my lord ଗୋଟେ copy solve କରିଥିଲେ ଭଲ ହେଇଯିବେ.
ମିଷ୍ଟର ଜେନା ସାମନ୍ତ 32 ଜେନା ସାମନ୍ତ ନାହାନ୍ତି କୁଆଡେ ଗଲେ ନା ଆପଣ 31 ରେ ଅର୍ଜନ ହେଇଛି ନା କଣ ଆପଣ ଡାକିଲେ 31 31 ଅର୍ଜନ ତ ଠିକ ଅଛି ତ ଜେନା ସାମନ୍ତ ସେ ନାହାନ୍ତି ଆଜ୍ଞା ସେ ନାହାନ୍ତି actually I have not reached actually I completed at 30 so ସେ ତ ନାହାନ୍ତି ତେଣୁ ଲେଟ୍ so it will be listed କେବେ ଚାହୁଁଛନ୍ତି
My lord, next week या फिर तापर
ନେକ୍ସଟ ୱିକ୍ ତ ଆପଣ କହୁଛନ୍ତି କପି ଆପଣ ଗୋଟେ କଣ୍ଟାକ୍ଟ କରୁନାହାନ୍ତି ସେଥିପାଇଁ କଣ କୋର୍ଟ ଅର୍ଡର ଦରକାର
ସେଥିପାଇଁ my lord problem ଲାଗୁଛି ମୁଁ କଲ୍ କରିବି
ଗୋଟେ ଆଣ 31 ରେ ଗୋଟେ ଡେଟ୍ କରିଦେ 32 ସରି
Will commence in phase 2.
ପେଜ 2 ୱିକରେ ଆସୁ
98
ନାଇଁ 33
33 ଟା ଆମର
ସିରିୟଲି ମୁଁ ଯାଉଛି ଗୋଟେ ଜଷ୍ଟ ଫର ପର୍ପସ୍
ମୁଁ ତାଙ୍କୁ କପି ଦେଇଦେବି
Mr. S. Chakraborty for the petitioner, Mr. K.C. Tripathi for the opposite party. You are Mr. Tripathi. Mr. K.C. Tripathi for the opposite party. Learned counsel for the opposite party requests for an extra copy of the petition. The learned counsel for the petitioner submits that he shall serve copy within 3 working days.
ଦେଇଦେବି କାଲି ଦେଇଦେବି
Within 3 working days. After Rajneesh versus Neha, from the date of application, the correct ବାଧ୍ୟ ଆପଣ ଏଥିରେ ଏ ମ୍ୟାଟର କାହିଁକି ପେଣ୍ଡିଂ ରହିବ କାହିଁକି ଏତେ କଣ ଡିସ୍କସନ କଣ ହେଇପାରିବ
I have not gone through the impugnation.
କରେକ୍ଟ ଆରେ ଆଜିକୁ ମୁଁ ନଉଛି କି ନା କଣ ଆଇ ଏମ୍ ଜଷ୍ଟ ଇନଫର୍ମିଂ ୟୁ ୟେସ୍ କେବେକୁ ରଖିବେ କେବେ ରଖିବେ ଲିଷ୍ଟ ଇନ୍ ଦ ୱିକ୍ କମେନ୍ସିଂ 23/2 liberty to mention
ସେଟା ଅର୍ଡର୍ସ ଆସିଲେ ସୁବିଧା ସରିଯାନ୍ତା
ନାଇଁ but then others will be thinking that I mean their matters so rest of the matters will be added distributed and acha gote 40 re gote order thibo 40 order
7 ରେ ଆଜ୍ଞା
say item 28
sir I have reached only up to 30
no
30 I have beyond that if I start taking up then
no that 28 items will also be asking for my learned friend Mr. Pati is appearing Mr. MK Pati is appearing
28 रे खाली लिखिबे CB senior
so my name may
senior ke naanti
my name may not
proceeding रे apne again this is a live proceeding
Adios.
So everyone knows you.
Yes, no.
I cannot make that he was looking like Mr. Pati or Pati was looking at Vibhuti. So only rhyming words.
Yes.
Vibhuti and Pati are rhyming. Mr. B.B. Misra, Senior Panel Counsel on behalf of M.K. Pati, Senior Panel Counsel. And Mr. M.K. Pati, Senior Panel Counsel. Yes.
His name may be reflected.
Both names.
ELRC.
Because the matter is disposed of. Must understand
yes,
why I'm.
Yes.
If you say adjournment, then it's better, no difficulty. But if it is disposed of, so item 40 is 40 is submitted by Mr. A.K. Pal, Learned Counsel, that the matter is mentioned. The matter is mentioned by the Learned Counsel for the Learned Instructing Counsel. Just give me a minute. Just give me a minute. Now you are there.
Yes.
Okay. नहीं तो you are AK Pal ना?
Yes, sir.
अपन मारोड़ा कहीं कौचुन?
item 40
बोलो अपन का ना लिखचुन थी Mr. अमिताभ दास senior advocate को पाइता अपन?
आज्ञा.
So I have got it correct. It is submitted by the Learned Counsel for appearance लिखने. हाँ, Mr. Amitabh इतने the matter of petitioner blank opposite party. Mr. A.K. Paul, PAL, Learned Instructing Counsel, for P1. It is submitted by the Learned Counsel, Mr. Paul, that Sri Amitabh Das, Senior Advocate, has been instructed to appear on behalf of the OP number 1 competent authority and LAO. Special land acquisition into bracket NH, National Highway, bracket closed. केबे फाइल कले आज्ञा वकालतनामा appearance memo केबे
आज ही फाइल
Aji. The Wakalatnama has been filed in the registry today, along with appearance memo of the learned senior advocate. Upon locating the Wakalatnama and appearance memo, registry shall do well to tag the same to the case brief. Stop. Para. Name of Mr. Amitabh Das, senior advocate, shall be indicated along with learned instructing counsel, appearing for OP number R respondent 1 from the next listing onwards. So all other matters.
Item 35, interim order to continue.
Sir, up to beyond 30, sir, only mention. Beyond 30, so I'm not touching any order. I'm trying to save some time there. So simply by adjournments, I'm not passing orders.
37 it will be
So any date you want, you just ask him.
37 item, this case was adjourned in the first hour. I am appearing for the Office 1 Union of India. That my appearance is not 37.
No, if it is necessary, then I have to pass an order. Otherwise, they cannot.
As well, Lords.
No, if you require, I have to pass an order. ठीक ଅଛି 37 Mr.
R.K. Mahapatra for OP1.
କିଏ mention କିଏ କଲେ?
Petitioner counsel.
Mr. ମହନ୍ତ ତ ନଥିଲେ?
Somebody has mentioned in adjourn according to adjourn. ND
Tripathi. 37 Mr. ND Tripathi for the petition of ND Tripathi on behalf of Devendra Mohanta. Mr. R.K. Mahapatra, senior panel counsel for OP1. The matter was mentioned by the learned counsel, Mr. Tripathi, seeking adjournment on behalf of the learned counsel for the petitioner. Accordingly, the matter shall be listed in the week commencing 6/4.
That's item 34, my lord.
You want earlier?
No.
Yes. Because today actually 2-3 matters they objected, so that is how I
No. Item 34, my lord. Pray for day after tomorrow.
34 after notice matter difficult, sir. Give some leeway, some space. Yes. ଯେତେ ଜଲ୍ଦି ହବ 34 ଯୋଉଟା କହୁଛନ୍ତି ଦେଖନ୍ତୁ ଟିକେ ଯେତିକି କରିପାରିବେ, but don't go beyond the capacity. There is no point in just adding to the list.